Okay, let's let everybody in, make sure you use the metal detector. Go over and help him with the metal detector. Okay? Use the metal detector, let everybody in. Got two more. I didn't see. Let him in.
Open the floodgates.
Oh, my gosh.
We said that at the exact same time.
Get off a rough start.
Jerry playing.
Yeah, first on the block.
Yeah, those three, when it's playing in the house down, will work. Pretty good.
They told me the next night he was playing, I go wait, Church Street.
I keep you
You
straight.
got to. North, and just. All that.
He's building out some people also.
Yes.
Yeah. I mean, it's from a false.
Yeah.
Okay, if we have any side conversations going on, we're broadcasting now. He's picking up. Okay. Christopher Burkett. Are you Christopher Burkett?
Yes.
Good morning. This is 25 CR 0077. Mr. Burkett, were you born in 1962?
Yes.
Last four digits of your social security number, 9537.
Yes.
We're on a pre-trial conference. What's the Commonwealth have to say?
Have a fellows.
Mr. Burkett, motion to tender says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CR 00077?
Yes.
Is your judgment impaired today in any way? Discuss this matter with your attorney. Are you satisfied with his advice?
Yeah.
Have you viewed the evidence the Commonwealth has against you, feel like you're fully informed about your case?
Yes.
You know, you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over with the, and I'll ask you to understand if you have any questions, step away from the podium and ask your attorney. You have the right not to testify against yourself. No one will make you say anything. The right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to be evidence, the right to know witnesses in favor, the right to appeal this matter to higher court if you lose, and the right to pray the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges. You understand that by entering a plea today, you give up those rights. Now, they consider the Commonwealth's recommendation, but may apply any range of sentence allowed by law. Prior to accepting the recommendation, I will wait a pre-sentence investigation report done by probation and parole. In the event after reading that I don't accept the recommendation, and you decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that? Okay, who will give the Commonwealth's recommendation? Mr. Stockton?
Yeah, Mr. Burkett will plead guilty to failure to comply with sex offender registry first offense. He'll receive a sentence of 1 year to serve, receive credit for time served, and he'll pay court costs at discretion of the court.
What is 155? 155. And we'll decide about that at sentencing. Is that your understanding of the Commonwealth's recommendation? Are you entering this guilty plea because you did commit the acts charged in the indictment and for no other reason? Knowing your constitutional rights to explain to us, it's still your desire to give up those rights and plead guilty and allow the court to fix your punishment. You understand that after entering a guilty plea, any future convictions could be enhanced as far as range of penalty. You understand that?
Yes.
I'll accept, is that your signature on there?
Yes.
I'll accept the plea, and order a pre-sentence investigation report and have this sentencing on March the 5th. Is there a sexual offender report required on this?
Oh, he's failure to register. No, sir. That was completed.
Okay,
previously.
okay, March the 5th, okay?
Thank you.
Yeah. Gary Flannery. Are you Gary Flannery?
Yes, sir.
Good morning.
Morning.
You're on 25 CR 0076. Mr. Flannery, is your year of birth 1978?
Yes, sir.
Last four digits of your social security number 5544.
Yes, sir.
We're on a pretrial conference. What's the Commonwealth have to say?
We have a felony plea.
Mr. Flannery, I've just been informed the motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes,
Is
sir.
this plea freely and voluntarily given?
Yes, sir.
Are you the person we just identified in indictment number 25 CR 0076?
Yes, sir.
Is your judgment impaired today in any way? Is your judgment impaired? You know what's going on? Any confusion?
I have some where I'm up.
Well,
I got some confusion, but
that's enough for me not to take a plea.
well, I mean, not on that part, just would this be transferred that back home to my
You got some
probation?
questions about what's going on. You want some time to talk to your attorney?
I've spoken with him. He wants to serve his time in Jackson County. I said that would be something that Department of Corrections would need
Yeah, I
to
have no control.
decide.
Oh, I've done talked to Bruce. We done got that understood.
Okay. So you don't have any other confusion? You,
No.
okay. You discussed this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
Okay, have you viewed the evidence the Commonwealth has against you?
Yes, sir.
You believe you fully understand all that?
Yes, sir.
You don't have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I'll go over those rights with you. If anytime you don't understand, you can step away and ask your attorney, okay?
So,
You have right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront, cross-examine all witnesses called to testify against you, right to use evidence, right to call witnesses in favor, right to appeal this matter, higher court if you lose, right to pray the Commonwealth to prove beyond a reasonable doubt that you guilty charge against you, understand that, and are you guilty, prove or you give up those rights, you understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided, well, I don't have to accept the recommendation. Prior to accepting any recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, sir.
Step to your left there, sir. Ms. Gordon Anderson, what's the recommendation of the Commonwealth?
Yes, Your Honor. Upon a plea of guilty to wanton endangerment, first degree, a class two felony, 5 counts, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. Upon a plea of guilty to assault third degree, 2 counts, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. The 2 5-year sentences shall run consecutively for a total of 10 years. Serve 270 days in jail with the balance probated for 5 years supervised. The defendant shall have no contact with the victims or the victim's real and personal property. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the Bostock case disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding, sir, of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the You're doing so of your own free will.
Yes, sir.
Okay, I know your constitutional rights, that explain to you still your desire to waive those rights, enter guilty plea, allow the court to fix your punishment within the range permitted by law. Is that correct?
Yes, sir.
Do you understand that after entry of this guilty plea, it's a felony, any future convictions could be enhanced as far as range of penalty on a persistent felony penalty law? Do you understand that?
Yes, sir.
Now, that's the signature, is that your signature on the motion?
Yes, sir.
I'll accept it. Order pre-sentence investigation report and have the sentencing scheduled for March the 5th. Okay.
Thank you, Your Honor.
David Hoschild. David Hoschild. Commonwealth versus David Hoschild, 25 CR 00123. Are you David Hoschild?
I am, sir.
Good morning.
Good morning.
Were you born in 1966?
I was, sir.
Last 4 digits, social security number 0822.
That's
We're
correct.
here for a pretrial conference. What does the Commonwealth have to say? What does the Commonwealth have to say?
We have a misdemeanor for the DUI program.
A motion has been tendered, sir, that says you wish to enter a guilty plea today. Is that correct?
So, yes,
Are
sir.
you currently under the influence of drugs or alcohol?
I am not, sir.
Is this plea freely and voluntarily given?
I am, sir.
Yeah. You are the same person that was identified in 25 CR 00123. Is that correct?
Sir, yes, sir.
Is the judgment impaired today in any way?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
I am, sir.
Have you read the evidence the Commonwealth has against you, believe you fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those.
I do, sir.
I'm gonna go over them with you just in case.
Thank you.
After I finish, then you can affirm. If you have any questions, just to step away from the podium and ask your attorney.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Right to speak trial, but jury right to be represented counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor. And process issue to compel their attendance. You have a right to appeal this matter higher court if you lose, and right to require the Commonwealth prove on a reasonable doubt that you guilty charged against you. You understand that when entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Now, what is I may consider the Commonwealth's recommendation that I may apply any range of sentence provided by law. Well, there's no felony now, so sentencing will take place today. After you say if you agree with this, then we'll go ahead and sentence. Mr. Stockton, what is the recommendation?
Yes, defendant will agree to plead guilty to operating a motor vehicle while impaired, first offense, receive a $200 fine and cost. The charge of wanton endangerment first degree will be amended to wanton endangerment second degree. He'll receive credit for time served. He's been in custody since November 23rd of 2025. And he would be released upon entry of the plea. And then he would pay court costs at discretion of the court.
What is the court cost?
That's
$820. Is that your understanding of Commonwealth's recommendation, sir? Are you pleading guilty because you did commit the acts charged in the amended indictment? You understand that after knowing your constitutional rights is still your desire to give up those rights, enter plea and let the court fix your punishment.
Yes, sir.
Okay, you understand that this DUI is a enhanced situation. If you get another DUI or each succeeding DUIs, the penalties go up. You understand that?
Yes, sir.
Is that your signature on the document?
It is, sir.
Okay, I'll go ahead and accept the Commonwealth's offer. 800 and what? You need some time to pay
I
that?
do, sir.
Okay, where do you live?
New York City.
Yeah.
Just outside New York City.
Yeah, well, I'm gonna just go ahead and take a chance on you paying that,
Thank you, sir.
because you, if you don't, you'll violate. So, probably won't extradite you from misdemeanor. We probably could save your life if we bring you back down here from New York City.
It's Ocean Port.
Okay, how much a month? Can you pay $100 a month, or would you do it have 75 or?
75 will be better,
Okay.
sir.
Okay, first payment due 30 days from today,
I'll be back.
and you'll need to, he's unsupervised, but will you need to get information from him today so we can release him?
We don't have nothing to do with it unsupervised.
No probation on this, Your Honor.
Yeah, the reason I did this, he got the DUI, if he never pays the court cost of fine, he'll never get his license back, so that's a big incentive for him right there.
Yes, sir. Thank you, sir.
Okay, well, we'll go ahead and enter the judgment.
Thank you.
Good luck to you.
Thank you. Thank you, sir. Thank you for the report.
Robert Hurt. Are you Robert Hurt?
Yes, sir.
Good morning. You're here on 25 CR 0116. Mr. Hurt, were you born in 1978?
Yes, sir.
Last four digits, social security number 5604. You're here on a pretrial conference represented by Mr. Poindexter. What does the Commonwealth have to say?
I'm waiting on the response from Mr. Farmer.
This is a good time, Mr. Poindexter.
It is, Your Honor. He gave us a counter offer. Mr. Hurt hadn't been brought up yet. If I could have time to talk with him in the back, we may be able to resolve it today.
Talk to him in the back.
Yes, sir.
Talk back.
Thank you, sir.
It's not against the rules if you talk before they come up here, though.
Well, no, he hadn't been brought up, so I went back there looking for him.
Well, you know where he was, though.
That is true.
Mr. Hurt wasn't gonna go anywhere. Justin Smith. Are you Justin Smith? Good morning. This is 25 CR 00120. Mr. Smith, were you born in 1976?
Yes, sir.
Last four digits, social security number 5761.
Yes, sir.
What does the Commonwealth have to say about this case?
My understanding was he was going to trial date last time I talked to you.
We have a trial set for this one.
Okay.
Yeah, March 11th.
What's the charge?
It's burglary. And it's already been set for trial now.
March of what?
March the 11th.
Yes. Okay, no pre-trial motions or anything? Ready to go.
Thank you.
You're in the hot period, you're gonna get trial. On the hot street.
Michael Taylor.
That's Mr. Poindexter's, not Mr. Mr. Poindexter's on that list too.
We'll have to wait on.
Well, no, we'll go, knock back there, Mr. Poindexter, come on out. Come on up here, sir. Come on. Your lawyer's back there talking to another client. That's what it is. Commonwealth versus Michael Taylor. 24 CR 0002. You are Michael Taylor. Were you born in 1984?
Yes, Your Honor.
Last four digits, social security number 2856.
Yes, Your Honor.
What does the Commonwealth have to say?
Your Honor, we submitted an order for mediation, I believe it's been signed. We just haven't heard from Judge Patton yet, about getting some dates.
And we reached out to his office. You haven't heard back.
Well, you know, appoint somebody else.
No, he's really good about that. I don't know, if we'll check with someone. That's good.
Why don't y'all have somebody call him today? And so we can go ahead and Okay, thank you. I guess the next court date will have to be noticed. We won't put it on for anything else since it's a mediation order. The Commonwealth versus Tyler White, 26 CR 00012 for arraignment. Are you Tyler White? Good morning. Represented by Mr. Poindexter, we're here for the purpose of arraignment. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with possession of marijuana, possession of controlled substance in the first degree, trafficking of methamphetamine, possession of drug paraphernalia, possession of handgun by a convicted felon, receiving stolen property of firearm, persistent felony offender second degree as far as possession of firearm, persistent felony offender second degree as far as trafficking of methamphetamine, persistent felony offender second degree as far as receiving stolen property. You know what? You understand those charges, correct? Mr. Poindexter, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
When is the negotiation day this month, Mr. Stockton?
It's February the 25th at 9 o'clock.
February the 25th at 9 a.m. You can have your client here on that date, Mr. Poindexter, and the next court date after that would be March the 5th. Okay, both of those are conditions of the bond if he makes a bond. Okay.
Yes, sir.
Great, thank you very much.
Thank you.
Tyler White. Assign a reciprocal discovery order. That's just a reciprocal discovery order so you can get the information about your case, okay?
Is it the 25th or 27th? Because you all said 27th.
Is it the 27th? I just wrote it down. Thank you.
It's the 27th.
Is that Mr. Poindexter?
I did, Your Honor.
That's negotiation. Tyler White.
That's him, Your Honor.
Oh, it was Tyler. Yeah. Yeah, is there anybody else in custody back there? Okay. Let's go to out of custody docket. Christopher Braswell. Commonwealth versus Christopher Braswell, 25 CR 0088. Are you Christopher Braswell?
Yes, sir.
Good morning.
Morning.
Were you born in 1998?
99.
1999, okay, we'll change that. Last four digits, social security number 5737.
Yes, sir.
Okay, you're here on a pretrial conference represented by Mr. Poindexter. What does the Commonwealth have to say?
He's set for trial March the 4th. Mr. Poindexter and I discussed it. I don't think there's any movement.
Not unless we do criminal mediation. I don't know if you want to try that.
What's the charge?
So you had that other trial on March 5th.
Yes, all 6 of you. So I've got March 11th. I don't mind mediating if you want to.
Is this a sex abuse case or what? We just tried. I didn't wonder.
Okay.
March 4th. Wow.
Okay, so yeah.
Thank you, Your Honor.
Charlotte Brown.
Yes.
Commonwealth versus Charlotte Brown. 25 CR 0087. Are you Charlotte Brown? Good morning. You have to speak up just a little bit. You born in 1984?
Yes,
Last four digits, social security number 0164.
yes.
You here for pretrial conference. What's the Commonwealth have to say?
There's an evidentiary issue we need to resolve. We'll continue this to April.
April the 9th. Do you want a negotiation day before then?
We'll set one by agreed order because Mr. Russell won't be in April, so I'll have to give the DBA.
Okay, that'll be fine. Shirley can answer. Commonwealth versus Shirley can answer. 25 CR 00074. Are you sure they can answer?
Yes.
Born in 1950,
Yeah,
last four digits, social security number 5060.
yeah.
What does the Commonwealth have to say?
Well, Mr. Kraus and I discussed this afterwards, so you're willing, if we can have one more negotiation day and then approve that.
Negotiation day on February the 27th, and next court dates on March the 5th.
Thank you, Your Honor.
He changed.
Yes.
I'm right. Which y'all notice that. Joshua Crawford, Commonwealth versus Joshua Crawford. 26 CR 00011. Are you Joshua Crawford?
Yes, sir.
You born in 1985,
Yes, sir.
last four digits, social security number 1639.
Yes, sir.
You're here today for the purpose of arraignment. Are you represented by an attorney?
No, sir.
Hey, we're gonna get him to fill out an affidavit up here. See if you, can you afford an attorney?
No, sir.
Listen, I'm gonna go ahead and appoint public advocate and he can fill the affidavit out, so slow up. You have a right to remain silent. The grand jury of Clinton County has returned the indictment charging you with possession of controlled substance. First degree methamphetamine and possession of red pepper. You know what the charge is.
Yeah.
Counselor, you acknowledge the identity of Mr. Crawford, receiving that formal reading of the arraignment, pleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Mr. Crawford is out on bond. There have been no excuses. I'm going to sign a reciprocal discovery order here. He shall come back here on February the 27th for negotiation day and March the 5th for his next court date. Both of those are conditioned to your bonds. Mitchell Finley. Mitchell Finley. Mr. Stockton.
Yes.
And Mr. Poindexter, you stay away from the Commonwealth Attorney over there. Don't interfere.
anything.
Okay. You can go over and talk to Mr. Hunley. He's not listening, so. Mitchell, where is Mitchell Finley?
Your Honor, the last I knew, he was in jail, and then I heard he's been released. I haven't spoken to him since and did not
The
make.
next time you want to talk to him, you can find him in the jail, because I need you to begin to.
And may we approach and elaborate on this, Your Honor?
You can talk to Commonwealth Attorney. Angela Frazo. How do you pronounce your last name?
Frazo,
Well, I've got pretty close.
yeah,
You're Angela Frazo.
yes,
Okay, good morning. You're here on an arraignment. You have an attorney? Can you afford an attorney? Okay, I'm gonna put public advocate and you need to wait around and fill out an affidavit about your financial situation. This is your attorney.
okay,
Grand jury Clinton County is returning an indictment and it's 26 CR 0010. Were you born in 1977?
yes.
Last four digits, social security number 7968.
No, it's 4968,
4968.
Yeah.
Okay, it's on the document. Okay, make note, 4968. The grand jury indicted you, charged you with improper equipment, improper registration plate, possession of controlled substance, methamphetamine, possession of drug paraphernalia, and license not in possession when it was made to them. Counselors, you acknowledge the advantage your client received indictment, waive formal reading arraignment, interpleading not guilty, returning all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order, man, that requires the Commonwealth to give your attorney all the evidence they have so that you can prepare for your defense. You are to be here on the 27th day of February for negotiation day, and your next court date's March the 5th. Both of them conditions of your bond, okay? Dusty Glidewell.
She's been around to see condition.
Are you Dusty Glidewell?
Yes, sir.
Good morning. This is 25 CR 0075. Mr. Glidewell, were you born in 1989?
Yes, sir.
Last four digits, social security number 4526.
Yes, sir.
You have a suppression hearing today.
Yes, sir.
Well, I did file a motion to hold advance, but Mr. Cross has informed me that he's no longer going to be representing Chris Young. I don't think he's made that official with the court yet.
I thought Corey, from you and Chris Young now.
Yeah, he told.
Okay.
And substitution. Yeah.
So he doesn't have a conflict, and so I can proceed with Mr. Clyde.
Okay.
And I guess my question is, I was looking at if the court can read the affidavit in the search warrant, I don't know that it needs supplemental testimony, but I'd be glad to get the officer up here to go through that with you if you want to. Because I think Mr. Little drafted this, and I can't hardly read it myself. It's difficult.
And all I would respond is if the officer comes up and reads it, I may bring Gary over to read it because I can't read it either. You know, it's just the way things are.
Who wrote it out?
Oh, Mr. Little, yes. So I'd have to get Mr. Sheriff here. I had him, so there it is. He's outside.
You can call a witness.
Okay, I'll call. Sure.
You raise your eyes and you swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Have you sleep there, lean toward the red microphone, state your full name and what your official capacity is.
Rodney Shelton, Deputy Sheriff, Clinton County Sheriff's Department.
Deputy Shelton, did you get a complaint from someone about a stolen washer and dryer? How did this arise?
Yes, sir. Got a tip from a confidential informant about a washer and dryer being at the property of Mr. Glidewell. Applied for a search warrant and received one to go look for the washer and dryer.
Now, looking through this affidavit on the search warrant, did you receive a tip from one confidential informant or two?
As I recall, I think there was multiple informants involved in it.
Okay. Have you reviewed this in a while?
It's been a few days.
Okay. You got your file in front of you?
No, sir.
Who drafted this, the search warrant? You know, that day.
Gary Little.
Okay. And did he draft that based on the information that you gave him?
Yes, sir.
And after you gave him that information and the affidavit was signed, were you placed under oath?
Yes, sir.
Did you swear to the truth and accuracy of the contents of the affidavit?
Yes, sir.
If I could approach the witness. See if you can look at that. If you can refresh your recollection or if you can understand.
It's kind of hard to read his handwriting, but
Mr. Cross, I'm going to review that here. Well, Your Honor, I'm going to object to Rodney looking at that before he reads this.
Look at what?
He's giving him this. I don't think he needs I think he needs to read this document for municipal conversation.
Well, I want to, he says he's having difficulty reading, so I want to refresh his recollection on the report. Let him give some background information if we need to call Mr. Little.
Your Honor, the issue is the legibility of this. If he's going to review this, then he's gonna be able to decipher that, and I just think I need to object to that, I don't think it's broke, I think he's the one that's placed under oath, he needs to be able to testify what he's worth at, without any profession. Well, I've never heard of.
Let me
Regulations.
see. Perhaps Mr. Little should have gone to medical school.
It's hard to read, but I.
Oh, it is.
Decipher it.
Yeah. It should be.
I don't have any trouble. He writes better than I do.
Well, that's not saying much, Your Honor.
And I'm not, it's an admission against my interest.
I'm pretty bad at oil. I'm good at it. It's not my strong suit.
Okay, you want to ask him any questions? I guess ask if the contents of that affidavit are true and you can pass it.
Are you able to comprehend or read that affidavit? There, Sheriff.
Yes, sir. I can decipher.
Okay, and based on that, you're reading the affidavit, does it contain the information that you provided to Mr. Wood?
Yes, sir. Seems to.
And was there one or more confidential informants that gave you information on the Washington Drive?
I had two informants that was advising about the washer and dryer.
Okay, and those informants, let's take them individually. Did you receive information from both informants at the same time or different?
Different times.
And are we talking about one or two individuals?
Two.
Yeah. The first individual, without naming who that is, had you relied on them in the past, that they given you information and proven to be correct?
Yes, sir.
Okay. Now, the second individual, I'll ask you the same question. Did you have a relationship with that individual?
Not personally.
Not personally, but you have a relationship with the patient?
Yes, sir. I was
And
familiar.
that individual giving you information,
Yes, sir.
and it had been proven reliable and correct facts.
Yes, sir.
Now, based on did both of them tell you that the washer and dryer was at Mr. Glyde's residence?
Yes, sir.
And was that at two different times? If it was, how much time in between were you about?
Probably within a day or so, a day or two.
And based on that information, you went to the payment, and the affidavit contained search warrants, is that correct?
Yes.
And did you and other officers execute this search warrant at Mr. Glyde's residence?
Yes.
And what did you find?
We found the washer that was matching in the affidavit. We found a 22 revolver out back and some drug paraphernalia inside the residence.
So the washer was recovered, but the dryer wasn't?
Yes.
Okay. And who did they belong to?
They belong to Miss Shirley Cross.
Okay. And prior to this search warrant being, authorized, how long had that been reported missing? Do you recall?
Stolen about 3 to 4 months ago, according to this affidavit, 3 or 4 months prior.
Now, did Mr. Gladwell, was he placed under arrest at the scene after you executed search warrant?
Yes, sir.
And was he Mirandized?
Yes.
Was he questioned about the washer and dryer?
Yes.
And what did he say?
I can't recall his exact statement. He stated that he had some sort of warranty registration for the washer and dryer. The dryer, he said his stepdad had taken it a day or two prior to our arrival.
Did he make any statements on how he obtained the dryer?
I can't recall without looking at my report.
Well, now that he's testified to the contents of the affidavit, may look into the court. You have an objection? Good. You're safe.
You're going to do this instant.
No, I just want him to review it so
Oh,
he can say if Mr. Gladwell made any statements about whether you obtained it or not.
Okay, go ahead.
I really don't think that's relevant.
Well, I withdraw.
Yeah,
I'm finished. Okay, Rodney, I need to ask you some stuff. You've got that Dave in front of you?
Yes.
Okay. We're looking at basically the four corners of this affidavit, and can you start reading after it says if I received information from, can you pick that up and read it from there on, sir?
A confidential informant who has proven reliable in the past stated that he delivered the washer and dryer.
Now,
to-
what's the word between he and deliver? Could you figure that out? I could not.
I can't.
Okay, keep going.
The washer and dryer to Dusty Gladwell. Something was told that the dryer were, I can't read the last two
Okay,
words. there.
that's fine. Keep going.
The owner of the owner, I can't read that word either.
Keep reading. If you can.
There's four words there that I can't read.
Which four,
Stated,
Rodney, do you know?
it's after the owner.
Okay. Keep this, just do the best you can
Stated
and
that
pick up where you can.
that the items were stolen and gave the serial number and descriptors. The owner is Shirley Cross. The item has been stolen for about 3 to 4 months ago.
Just keep going.
I think it says both. Find information or something, who for reliable information in the past. Told in a fine about 2 hours ago that the items or something were at Dusty Gladwell's residence. The items are valued at approximately 1,500 combined.
Okay, thank you, Deputy Shelton. Now, the question I have for you is, there were several words in here that are very difficult for you to construe, and
Yes.
that's impossible. So can you truthfully say that the contents of the affidavit are true and correct if you couldn't read parts of this?
He was reading it back to me as he was writing it.
Okay,
As he was writing it out, we were discussing what
okay.
my statement. So he was kind of talking back to me what he was writing in the affidavit. There's words written in this affidavit that are kind of hard to make out in his handwriting.
Now, it's unclear to me, you received information from the first informant, and then you did your follow-up with a second informant,
Yes.
right? Okay. I do not see where it says when these people saw the dryer and the washer at Dusty Gladwell's. Can you point that out to me?
It says something that 2 hours ago in the
Okay.
Third
so-
line up.
So let me read this. Another, and I'm gonna read what I think it says, another confidential who has been reliable in the past told something about 2 hours ago that something was still at Dusty Gliders.
Yes, that's
So
how I interpret it.
but I take that to mean you got the information 2 hours ago. Is that correct?
Say that again.
The way I read this, it says that the informant told you about 2 hours ago. Is that correct?
At the time I talked to the informant, which was around the time that I got the affidavit,
So.
that's the 2 hours prior to that.
So what you were doing here, you were establishing that you very recently got the information from this second informant. You got it about 2 hours ago. Is that correct?
That's correct.
Right?
Yes.
No further questions. Did either informant tell you when they saw the water drive building?
The second one had told me that they saw it within a few hours, or within a couple of hours of me talking to them.
And did you relay that information to people?
Yes,
And you thought that was in the act?
yes, it says about 2 hours.
Okay, that's the way you interpret it.
Yes,
I have that further. But Deputy Shelton, that's not what you answered a moment ago. I said you were establishing that the information was received within the past 2 hours. So was that not correct?
no, I talked to the informant just before I got the affidavit.
I understand it.
They stated
Let him
about
finish his answer, please.
2 hours prior that the washer and dryer were there, prior to me talking to them.
So it's your testimony today that what this says, 2 hours was 2 hours prior, correct?
To me talking to them, yes.
Now, am I correct, though, you previously testified you had no experience with this secondary informant whatsoever, is that correct? That's actually, I'm gonna check, that's mischaracterization of his testimony. Well, I mean, I asked if that was correct, so when you say it's that correct, it's not mischaracterization. What was your previous experience with,
Qualified.
yeah, what was your previous experience with the second informant, Rodney?
I've known them and had contacted them through work since,
When you say
For a while.
contact through work, had you had occasion to arrest such an individual?
not that I recall.
Okay. Had you ever obtained any information from the second individual previous to this time?
Yes,
Okay. A while ago, you said you had, at least that's what I understood. So
no, I said I had,
if you said you had on the first one, but not on the second one, is that not correct?
no.
Okay. No further questions. No regrets.
This officer be released, you can thank you for coming here today. Be excused, thank you. Is that all you have?
That's all I have unless you want me or Mr. Cross to call Mr. Little Ray Daffy.
Yes, sir.
Not necessary, okay.
Not necessary.
Not for me.
No, well, wait a second. We'll tell you whether you're necessary or not. Mr. Cross, do you have any witnesses you'd like to call?
No, Your Honor, I do believe that under
Can
the,
Mr. Little be excused then?
well, for what? I don't, we'll excuse his handwriting, we will. Well, if you can't read it, you might not be able to question. Okay. Fair enough. Your Honor, there's been some things testified to by the officer today. First of all, we're not gonna put Dusty on, but, or any other witness, but I'd like to have an opportunity to brief because I think we've gone beyond the 4 corners today. And I'd like to just file a memorandum regarding.
I will not consider anything that is beyond the 4 corners. I have enough self-discipline that I can refrain from doing that.
Well, if that's
If you want to brief it, that's fine.
I'd like to have an opportunity to brief it. To give me
If you allow Mr. Cross to brief it, I would like to be able to respond to that brief instead of doing simultaneous brief, because I don't really know what he's going to argue, because
if this is not a valid search warrant, I don't think you could ever put in anywhere that you rely on confidential informants. We'd be making new law, you know, about that, because he's got two informants.
Well, I will
both
tell you,
reliable.
I'll tell you both that I will not intentionally be a party to making a new law. I might be a party, but I won't be intentional.
Your Honor, right there, 10 days, I'll get something to you.
That'll be fine.
And y'all will reply in 5 days.
That'll be fine.
Yeah.
Thank y'all very much. Yeah, let's have back in court, Mr. Cross. Have your client back in court on
Fifth.
March the fifth, okay?
uh,
Catherine Gould. Are you Catherine Gould?
Yes.
You're on 26 CR 008 for the purpose of arraignment. You born in 1998?
Yeah.
Last 4 digits, social security number 0607.
Yeah.
You said that you have zero income. How do you live on it? When's the last time you had a job?
In November of last year,
You what?
in November of last year, or March of last year.
You know, what's the deal? Why don't you have a job?
Because I was just taking care of my son at the moment.
You receive no welfare, no food stamps, no social security, no workers' comp, no unemployment, no retirement. You don't receive anything.
No.
How do you live?
I was receiving those benefits, probably about 6 months ago, and they got canceled. When I was, incarcerated because of this.
When's the last time you went to the grocery store?
I don't know.
I mean, who are you
well,
living
I
with? I
live
mean, you
with-
give me an affidavit,
No, I
raise
live
your
with-
right hand. Swear the testimony you're about to give is the truth, whole truth, and nothing but the truth. Where do you live?
Now I'm living on 76 Falls Road. I was living on Cat and Mouse where this all happened, and once
You
that
live on
happened,
76, whose house do you live in?
Rita Stonecyphers?
Are you paying her any rent?
No, not Luna.
Okay, who pays your utilities?
She pays utilities right now.
Okay, and who buys your groceries?
She does.
And are you a friend of hers or what's the deal?
Yeah.
Does she live there too?
Mhm.
Okay. Okay, well, I'll sign this thing. I'll reserve what I'm gonna charge. No, Mr. Wilson. Sir. Here for the purpose of arraignment, you have the right to remain silent, you have a turn. Okay. The grand jury of Clinton County has returned an indictment charging you with fleeing or evading police officer, resisting arrest, possession of controlled substance, methamphetamine, possession of drug paraphernalia, and wanton endangerment in the first degree. You understand those charges?
Yes.
You understand what the charges are?
Yes, except for the last charge. There was a discharge of firearm charge.
Don't talk about the case. Step away and ask your attorney. Step away from the podium there. You understand what the charge is? I'm not asking you to do it. Okay? I'm signing a reciprocal discovery order that requires the Commonwealth to provide you with information concerning preparation of defense. Be back here on the 27th of February for negotiation. And March the 5th for the next court date. Both of them are conditioned to be bond. Thank you. Kyle Norris. Commonwealth versus Kyle Norris. 26 CR 004 and 25 CR 00117. You are Kyle Norris? Yes. Good morning. Morning. You here for a pretrial conference. You were born in 1988? Yeah. Last 4 digits, social security number 3777. Is that correct? 9777. 9777. We have a typo. 9777. Okay, well, you have a report.
Yes.
Get it right now.
I don't see that on here, so. Local and pre-trial conferences. This is in 0004. So that should be it. Grand jury of Clinton County is returning to theft by lawful taking of first position. Criminal mischief in the first degree, burglary in the third degree. You understand what those charges are? Yes. Counselor, you acknowledge the receipt of indictment, the identity of client, waive formal reading or enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order here. It will require the Commonwealth to provide you the information you have on this new indictment. To help you prepare for the defense. Negotiation day on the 27th, next court date on the 5th.
Thank you.
Yeah, Mr. Wait, before you go now, was this second offense committed while he was out on bond?
I don't think so. I believe this is the latest step to third prior.
Okay, thank you. If you find out differently, you may go. Caleb Purdue,
He has an active absconder warrant, Judge.
Yeah, we're putting it in the asset.
Mitchell Thrasher. Mitchell Thrasher.
I know he's had some help on him recently, Johnny.
I'd ask for a summons next court date, and the reason I would do that is I would need him in the case of Commonwealth versus Bethany Harding. And if I'm gonna set her for one more pretrial and she doesn't enter a plea next month, I'm gonna ask for a trial date in her case. She's got 2 cases.
You want to do a bench warrant, you want to do a warrant for him and then set a ROR? or-
That is, I don't want him held, she's the jail for the time.
Okay, well, let's do a bench warrant for Mitchell Thrasher and set an ROR bond. Okay. Anthony Troxel says active warrant.
And we're putting him in the asset.
Terry Willis. Commonwealth versus Terry Willis. 26 CR 0009. Are you Terry Willis? Good morning. You born in 1973, Mr. Willis. Last 4 digits, social security number 3384. You here for the purpose of arraignment and you have an attorney. Can you afford to hire an attorney? We do an affidavit, but I'm gonna have public defenders sitting up first. The grand jury of Clinton County has returned an indictment charging you with illegal taking or pursuing a bigger 14 counts and tampering with physical evidence 14 counts. You know what the charge means, so I'm gonna ask you if you did it or not. You understand what the charge is, what the charge. Counselor, you acknowledge the identity of your client received indictment, very formal reading arraignment, interplea not guilty, reserving all proof and motion.
Yes, Your Honor.
Set a negotiation date, February 27th, the next court date on March the 5th. Sign reciprocal discovery orders, so the Commonwealth must give you evidence they have. Prepare for defense.
Thank you.
Christopher Young.
Excuse me.
Are you Christopher Young?
Yes, sir.
Good morning.
Good morning.
You're on 25 CR 00118. Mr. Young, were you born in 1995?
Yes, sir.
Last 4 digits, social security number 7276.
Yes.
Represented by the Office of Public Advocacy.
Your Honor, I don't know if you feel that affidavit at gunpoint because Mr. Cross represented me privately. So I think you have to be qualified.
You representing this guy again now?
Well, again, I'm not sure. I haven't been appointed to him. As of now, of course, I'm happy to represent him. That's what the point means with them.
Yeah, well, it's just a pre-trial conference. You hadn't talked to him. I'll set a negotiation day up for the 27th of February at 9 a.m. and the next court date is the 5th, and within 24 hours, you need to tell him if you got a conflict or not, so you can have other counsel present. Is that all right with you, Mr. Stockton?
Yes, sir.
Okay. You understand, they don't know whether they got a conflict of interest on your case or not. He's going to interview you to see if he does. They'll have some, you'll need to talk to a lawyer before we go to negotiation date on the 27th. So that you can be aware of your case, okay? Steve? Yes.
On Mitchell Thrasher, we had pushed that case out to April last night, and somehow it ended up on the docket this month, but he was told to come back in April.
We do a bench warrant.
Yeah.
Withdraw the bench warrant on Mitchell Thrasher. Did y'all catch that? Okay, Mickey Shelton at
Your Honor, we've got,
Eastern Kentucky Correctional Complex.
we've got Jerry Brad out here, and we've bypassed him some way. You want to take him up before you get up?
Just a hair bit more. Thank you.
Megan, did you say?
Well, let me do this. I've got these people on Eastern Kentucky Correctional Institution, Mickey Shelton. Are you there, Mickey?
Yes, I am. Hang on just a second, Judge. Hey, ma'am, will you click this off here?
In jail, you need to turn your camera off until we call your case, please.
See right here. Does that stay on there? Thank you. Yes, I can.
Turn Wayne's right. Wayne County, turn your camera off until your case is called, please. Thank you. Thank you very much. Are you Mickey Shelton?
It's no Zoom on it. Hang on just a second. We got my camera. Yes, my name is Mickey Glenn Shelton.
Okay, were you born in 1970?
Yes, sir.
Last 4 digits of your social security number 7583.
Yes, sir.
You're here on 24 CR 0085. You're represented by the Office of Public Advocacy. What does the Commonwealth have to say?
Well, he's been, represented by Mrs. Delaware, and I heard that she was in here.
Yes, Judge. Thank you for accommodating me.
Are you up there, ma'am? Would you turn your camera on?
I have my camera on and unblocked. I'm not quite sure why it's still black.
Can you hear what's going on?
Yeah, I can, Judge.
What do you have to say, Mr. Stockton?
Well, I need to know if they want to negotiate the rest of this case, or if they want a trial date set. I don't know what they want to do.
Well, I'm sorry, I didn't mean to interrupt. I would like to negotiate. Mr. Shelton and I had a long conversation, and I understand what's going on with this case more than I did previously.
Negotiation date on February the 27th at 9 a.m. here in Albany. You'll need to submit a transportation order.
Okay.
To have him here. And then your next court date after that is March the 5th. Both of them are conditions, okay?
Thank you, Judge.
Thank you. Mr. Shelton, you can turn your camera off. Your attorney will be in contact with you. Russell County Jail.
Yes, sir.
Not a problem.
What do I do?
Bethany Harding.
Yes.
You are Bethany Harding.
Yes, sir.
This is 25 CR 00121 and 25 CR 00086. Ms. Harding, you born in 1992.
Yes.
Last 4 digits, social security number 0901. Mr. Cross is present, represents you as a Commonwealth representative.
Well, we've got both cases now arraigned, and I'm gonna do one more pre-trial conference back to I we set the trial date.
And that's agreeable.
February the 27th is negotiation and March the 5th If you want it brought here, you'll need to be a transportation.
I will be doing that. I'll have you over that day, Bethany, but I'll come see you first. Thank you.
Okay. Now, do you have somebody that's present that's not on the docket before I get into Wayne County? What's the charge?
Was it around,
Okay. What's the gentleman's name?
Jeremy Brad.
I'm sure, so, but.
Yeah. Make law.
Yeah, important, it's just not reflecting it on.
Would you give me Mr. Braswell? File.
It's 26 CR7.
You said 26 CR7.
26 CR 0007. You wasn't on the docket, so there he is. You can come around. You are Jeremy Braswell, is that correct?
Yes, sir.
What's your year of birth?
Jan 31, 1980,
1980 is your year of birth, well, the last four digits, your social security number.
7231.
Okay, you're here today, you have a right to remain silent. You're here today for the purpose of arraignment, you're represented by counsel. The grand jury of Clinton County has returned an indictment charging you with assault in the fourth degree and strangulation in the first degree. You understand what the charges are?
Yes, sir.
Mr. Cost, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty with voting all pre-trial motion.
Yes, Your Honor.
Set a negotiation date up on February the 27th, 9 a.m. and your next court date is March the 5th. The condition of bond is stay away from the alleged victim. Okay. Wayne County, sign a reciprocal discovery order. Wayne County. Wayne County, are you on there? Okay. They weren't. Yeah, I had them turn the camera off minutes ago. They probably disconnected. Could you, we're going, Wayne County, are you back on? No. Okay, let's go to Clinton County. It's not set to 10:30, so let's see if we can call Wayne County, see if we can get them back on. Clinton County will be with you in just a moment. Kimberly Elmore. Turn your microphone on, Wayne County. Turn your microphone on. The little thing that looks like an old microphone. A corn cob. Maybe it looks like a corn cob.
How about now? Can you hear me?
Yeah, you got it. Good job. Let's
Okay,
find
thank you.
Kimberly Elmore.
They need the Timothy Elmore, that female in here. 8:28, and need to sleep in.
Okay, while you're
Judge,
getting.
we got the males in here right now, and she's gonna go get the female.
I'll do them, okay. Jeremy Kempton. Jeremy Kempton. Are you Jeremy Kempton?
Yes,
Good morning. Were you born in 1981?
yes,
Last four digits, social security number 2874.
yes.
This is 23 CR 0030. You're here on a probation revocation. It has listed Mr. David Cross as your attorney. Public advocacy's taking over the case. Mr. Hunley, what do you have, Mr. Kempton?
We have a motion to revoke probation, Your Honor. It's a complex issue and I need to know, do I have officers Lang and Bertram available? Okay, Cash, you with it. What about Lang? And Bertram,
Yes,
you there?
yes, I'm here.
Who are you?
Yeah,
Nick Bertram.
What-
Gary.
Bertram.
Morrow, are you involved in this case?
Yeah,
I am, Your Honor.
Okay, Alan Cash, you're involved, Nick Bertram, you're involved, and Deputy Casey Lang, you're involved, correct?
Yes, Judge.
we're ready now.
Will you just tell us what the what it is, see if they stipulate?
I doubt that they will, but Mr. Kempton was convicted in 2023 of assault in the third degree. He was probated by this court later and has been on probation since then. He's had a couple of minor infractions, but that's not what we're here about. This infraction rises out of an incident on December 3rd, 2025, last year. The officers, Bertram and Lang, were dispatched to a site in Wayne County. The residence of Angela Guerrero had been called in, I think, by some neighbors. But when they arrived there, they found her covered in blood, holding her right hand, reported that her friend Jeremy returned home intoxicated, accused her of cheating, became aggressive, beating items in her home. Then he, Mr. Kempton, retrieved a knife and attempted to stab her, did make contact. And when the officers, that's her testimony. Now, the officers arrived and that would be officers Bertram and Lang. And they found the defendant there, covered with blood, and a knife near him, located near him on the driveway. Kempton admitted to coming home, accusing Angela of cheating. an engagement in an argument. The victim in this case told the officers at the scene, and I'm assuming in the presence of the defendant, that she led me to the bedroom. I observed a significant amount of blood on the floor, bed, and walls. Additionally, there was a stab wound in the wall leading to the bathroom. The officers reported the violence to EMS, and they did arrive at some point. Mr. Kempton declined any services, and I don't have a medical report on him, but somebody has filed an affidavit. I think it's an affidavit that basically says that Jeremy Kempton came to my work, was drunk, came in from work, was drunk on liquor. I asked him to leave. He started going off, breaking my belongings. I asked him again. He went to the kitchen, got an old knife, came toward me, held it to my throat. Jeremy said, "I will kill you, bitch." Started beating me, still holding the knife in his hand, cut me.
Yeah, I get an idea of how it's.
Yeah, the only witness I don't have here today is Angela, and she may be here.
Well, she's gonna be in the Cumberland Circuit Clerk's office in just a few minutes to testify to Zoom, if that's okay.
Yes, fine.
But that's basically the case.
You want to stipulate, of course.
No.
You want to call your first witness?
I called Deputy Bertram.
Deputy Burton, be raised your right hand, you swear the testimony about to give us the truth and the whole truth.
Yes, I do, Your Honor.
How do you proceed?
Deputy, what's your present occupation and by whom are you employed?
A deputy sheriff in Wayne County.
And did you hold that job back in December of last year?
Yes, I did.
Have you heard me recite the preliminaries of what we're here today for?
Yes, I'm also just the assisting officer. Deputy Cash was the.
Well, were you one of the officers present there at the incident, where the incident occurred?
Yes.
And Officer Lang was the other officer present?
Officer Lang and Deputy Cash.
Deputy Cash was present as well?
Yes.
All right. Well, I've got you. Tell me what happened that day and what you saw and what you found.
On December the 3rd, shortly after 9 p.m., deputies responded to a residence located on East Highway 92 in the Oil Valley Trailer Park. It was in reference to
Wayne County, is that right?
Yes.
Go ahead.
It was reported that a domestic violence disturbance was occurring there. When I arrived on scene and with deputies, shortly after Deputy Cash and Officer Thompson with the Monticello Police Department was present. Upon my arrival, I observed a male subject standing outside the residence near the porch area, which as I approached the residence in my patrol vehicle, I then observed a knife laying in the gravel driveway there. It was directly right in front of my vehicles when I pulled in. We then entered the residence.
Where was the defendant in relation to the knife that you found?
He was standing outside in front of the porch, within 10 feet, 15 feet from the knife.
All right, thank you. Go ahead.
Deputy Cash and Officer Thompson was with the victim at the neighbor's residence, and myself and Officer Lang, I believe. It may have been Officer Thompson, I'm not sure to be exact, but we approached suspect. I read him his Miranda rights while we were there. We went inside the residence. There was blood all over the floor. Stuff had been broken. There was blood all over the bed. And basically that was my part of it, of assisting Officer Cash as he was the charging officer.
You said that you read the defendant his Miranda right?
Yes, and now all that was on body camera as well.
I'm sorry, I didn't understand what you said.
All that was on body camera. Yes, I did.
All right. What kind of response did he make to the charges while you were there? Sir?
He spoke to Officer Cash more about all of that.
right.
You'll have to get into it with him on that.
Did you see the victim, Angela Guerrero, that night?
Yes.
Did you see any wounds on her?
Yes, on her hand. It was a clear stab wound with a knife.
Any other wounds around her arms or face?
It was dark, so I just looked at her briefly, because EMS was there.
All right. Did anyone there have an interview with her, with Angela?
I'm sorry?
That night, did any of the other officers interview Angela?
Yes, Deputy Cash.
Cash?
Yeah. Yeah.
Were charges levied against the defendant?
Yes.
What was the nature of the charges?
I believe it was assault second, domestic violence. I'm not sure of the others. Like I said, I wasn't the one that charged him with this.
All right.
Charges.
Thank you, Officer. Now, would you answer Mr. Rutherford's question?
Hello, Deputy.
Hey.
Just have a questions for you. At what point did you actually get involved in the incident?
I was there just a few minutes after Deputy Cash and Officer Thompson was there. They had already been speaking to the victim. There's two trailers within close proximity of each other. She was at the neighbor's. So just a few minutes briefly, just after they had gotten there.
So it was after the confrontation had concluded?
Correct.
Are you aware of whose home that this incident occurred at?
I'm certain that it's the victim's. Angela is renting that trailer there along with the suspect. It's a rental trailer.
And let me ask you, when you saw Mr. Kempton that night, did you notice any injuries that he had sustained?
Not that I'm aware of.
Are you aware if he went to the hospital after that incident?
Don't think so, but he might have.
How was his demeanor when you arrived on the scene?
He was clearly been drinking, intoxicated, manifestly under the influence, from my observance.
But he wasn't irate at that time?
Not with us, no.
That's all the questions I have.
That's the brother of this witness, Your Honor. I'd like Officer Deputy Cash.
It's a victim. One of the victims in the clerk's office yet.
I don't know.
Yes.
She is. Turn that camera on to the clerk's office, please. Let me raise your right hand, please. In the courtroom there, you swear the testimony about to give us the truth, whole truth, and nothing but the truth.
Yes, sir.
You may inquire, Ms. Sherman.
What is your name, please?
Angela Guerra,
And Ms. Garrett, where do you live now?
290 Willett Road, Burkesville, Kentucky.
And where did you live back in December of last year?
2120 West 52, Monticello, Kentucky.
All right. Now, at that time, were you in some sort of relationship with the defendant?
Yes.
What was the nature of your relationship?
It was going fine till,
Was he your boyfriend?
yes.
All right. Was it your house that you all were living in?
Yes, we had rented it together.
Okay, so you all were living there together.
Yes.
Did something happen on that night, December 3rd, that causes you to be here today?
He came home from work. He was on liquor. He was upset about something with his job, and we went to his mother's. Everything was fine, and then when we got back home, I had cooked supper for him, and he just went off. Thought I had a man in the house.
You asked him to leave?
I just told him that he wasn't supposed to be a drinking. The landlord didn't want it here, and that's when he just flipped out.
When you say flipped out, what was he doing?
He went to the kitchen, to the silverware drawer, pulled a knife, and he hugged me with the knife.
Was he breaking up your belongings or anything before he got the knife?
He had broke my table in the living room.
Right. And is that when he then went to get the knife?
Excuse me?
At that point, is that when he went to the kitchen and got the knife?
No, he had already had the knife. He took the knife. I was sitting on the couch, and he took the knife and he stabbed it beside my head, and he said, "I'll kill you, bitch."
He did what?
He stabbed beside my head and told me, he said, "I'll kill you, bitch."
Where was he holding the knife?
Do what?
Was he holding the knife to your throat saying, "I will kill you, bitch"?
Yes.
And he started beating on you then?
Yes.
He cut you in any other places besides?
He scraped my nose, he cut my hand, and I had a slice on my leg.
What about your thumb?
Excuse me, sir?
He stabbed you in your right thumb?
Yes.
Then what happened after that?
He made me get up out where I was sitting in the living room, had me to go to the bedroom. He started breaking stuff, and he made me strip off naked. And he told me he should rape me with this knife, with the knife that he had.
How'd you get away from him?
When he stabbed himself in the bathroom, he like wilted to the floor. And when he started wilting to the floor, I ran to the back door and escaped.
Where did he stab himself? What part of his body?
In the left-hand side of his stomach.
Is that when you got away from him?
Yes.
What did you do?
How did I do it?
No, what did you do after you got away from him?
After I got the back door unbarricaded, I ran to the next door neighbor.
All right, what, did they call the law?
Yes.
And the officers that came?
Yes.
Ambulance come?
Excuse me?
Did the ambulance service come?
Yes.
All right. They take you to the hospital?
Yes, in ambulance.
Do you know if he received any treatment of any kind?
They just sewed up my hand, and as far as him, he was there. I mean, he come later after I was sleeping.
Did he get any treatment?
He showed up at the hospital when I was, getting released.
So do you know if he got any treatment?
No, I do not know.
All right. Now, did you, that night or soon thereafter, did some of the officers write out a statement and ask for you to sign it or ask if it was your statement?
No, sir.
Do you recall relating to the officers what happened that night, and some of them wrote it down?
I did tell them what happened, and as far as them writing it down, I never seen nothing wrote.
Okay,
Now,
let's move on.
now, at the time that you and Mr. Kempton were living together in Wayne County, he was a convicted felon, wasn't he?
Yes,
And were you also a convicted felon?
yes.
What was the nature of your felony?
Possession.
Were both of you on probation?
Yes, but he had been to court and he had told me they had dropped off his, charges.
Well, did you have your permission from your probation officer to associate with him?
No, sir.
If you know, did he have permission from his probation officer to associate with you?
No.
That's all I have.
Only got a few questions for you. You said, when Mr. Kempton returned home that he was intoxicated?
Yes,
How did you know he was intoxicated?
cause I smelled the liquor.
So he didn't tell you he was intoxicated?
Excuse me?
Did he tell you that he was intoxicated?
Now I could tell.
Then you went to his mother's house, is that correct?
Yes.
And at his mother's house, everything was fine?
Yeah, everything was fine when we went to his mother's.
How long were you at his mother's home?
About an hour.
About an hour? And now how far away does his mother live?
She lives in Alpha, Kentucky.
And where?
Alpha,
Okay. About how far away is that from your residence?
about 20 minutes.
Okay. Let me ask you, are you the owner of the home, or were you the one on the lease for the home that you were residing in?
No, I'm not no owner. No, he was the one on the lease. He was the one that was on the lease.
So how long were you at home before this alleged incident occurs?
He come home about 2:30 that evening.
But how long were you at the house after visiting his mother, before there is some type of argument?
About 30 minutes.
And was there any discussion or talking before, the argument got violent?
No, he wanted my phone and I couldn't find my phone. Well, so happened I had left it at his mother's and he thought I had had a man there at the house.
Something you said earlier was that Mr. Kempton stabbed himself.
Yes.
How did that occur?
What time did it occur?
How did it occur?
We was in the bedroom, he was breaking up my stuff and he made me strip off nude. And he told me that he should rape me with the knife. And he made me stand there. He was in front of the mirror in the bathroom and he took the knife and stabbed himself on the left-hand side.
He purposefully stabbed himself?
Yes.
You know why he would do that?
I don't know. He just told me that I wouldn't see daylight and he wouldn't either.
So at what point did you did you go outside? Did you leave the residence? At what point did you leave the residence?
I left the next morning.
Is that when you called the police?
No, that was, after.
When did you call the police?
It was around, 11, maybe, 10:30, 11.
And so how long after the confrontation did you call the police after your argument?
After the argument, after I got out of the trailer, I called, it was probably around between 10 and 11 that night.
Do you know about how long that was after your argument with Mr. Kempton?
No.
So when you called the police, what injuries had you sustained at that point?
The injuries on me,
Yes, yes.
my hand, I had a cut on my leg, and he had scraped the top of my nose with a knife.
That's all the questions I have, Your Honor.
Mr. Hunley?
When you say your hand, is that, you mean your thumb?
Yeah, my thumb.
What kind of treatment did you receive?
They just sewed up my thumb.
All right. Now, I have nothing further to this witness, Your Honor.
It should be released.
Yes.
You
As
may be
for my
released.
concern.
Yes, Your Honor.
Call Deputy Cash, please.
Deputy Cash, you raise your right hand, you swear the testimony you're about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Identify yourself on whom you employ and mark capacity.
My name is Deputy Cash with the Wayne County Sheriff's Office.
Deputy Cash, have you heard what's happened here this morning so far?
Yes, sir.
What was your role that night in December of last year?
I was the arresting officer. I was the first one on scene.
All right. Tell us what you found. Tell us about how you were informed of an incident and what you did.
Okay. On December the 2nd, was dispatched to a possible domestic violence out Oil Valley Trailer Park. When I arrived on scene, I went to where the call was initially at. I made contact with the caller. It was the neighbor. She stated that I don't want to mispronounce her last name, Miss Guerrera, had been stabbed. I made contact with Miss Guerrera. She was holding her hand. There was blood all over she was in the neighbor's house, in the kitchen.
Go ahead.
When I made contact with her, she had blood all over. She was holding her hand. She had stated that her boyfriend had stabbed her. She didn't know where he was. She assumed still down at the trailer right next to hers. Then it was at that time, Deputy Lang, Deputy Bertram made contact with Mr. Kempton. So contacted EMS for her, made sure she was going to be safe. Walked down, started talking to Deputy Bertram, Deputy Lang, and when we finally brought her down and she showed us showed me where everything had happened. And
Where had
then
everything happened? What did she show you?
as soon as you walked in, as soon as you walked in the house, there was blood all in. When you first walked in, there was blood all the way into the kitchen. As soon as you walk in the door, you make a right into the bedroom. There was blood all over the floor, all over the bed. There was a knife stab in the wall. There was blood on the cabinets. Blood in the bathroom. Everything had been flipped over in the bedroom. And then in the living room, we went in there and there was a coffee table it was a glass coffee table that had been busted. And then at that time we had found enough evidence. And then we also had found the knife right around that time. And then EMS had showed up. It is on body camera. I don't know if it's mine or one of the other two deputies, of asking him if he needed any EMS treatment. He stated no. Later on, when I got him to the jail, he then stated that he needed treatment for his hand. I ended up taking him down to the hospital for it. I want to say, put some glue in it.
At some point, did he make any admissions, like admitting to coming home and accusing Angela of cheating? And
Yes,
then
sir.
Argument ensued.
Yes, sir.
Did he elaborate on anything?
No, sir. He just said that he came home, accused her of cheating, and they engaged in an argument. That's about it.
You also indicated that there was a stab wound in the wall. Has anybody been subsequently?
This is, let's shorten this up. This is not a trial. Yeah, I think.
Yes, now he's been charged with that too, criminal mischief by the landowner, isn't he?
I contacted the homeowner. I never did hear anything back from them. And it was multiple times I tried to contact them to see if they wanted to pursue charges on it.
Did you later interview Angela, the victim?
After the incident?
Yes, sir.
I don't think so, no.
All right. Did you or any of the officers there take a written statement from her?
While we were on scene, not that I know of, sir.
Or soon thereafter?
Let's move on.
Trying to, Judge.
Not that I know of, sir.
All right. Now would you answer Mr. Ruffins' question, please?
Go ahead.
Hello, Deputy.
Hello, sir.
So you were the initial officer on the scene, is that correct?
Yes, sir.
When you got there, do you remember where Mr. Kempton was?
No, because I didn't make contact with him first. I made contact with the caller and Miss Guerrera.
So Miss Guerrera, you made contact with her first, is that correct?
Yes.
Where was she at?
She was at the neighbor's house.
She was at the neighbor's house?
Yes.
And what was her condition at that point?
All I seen was just a cut on her right hand, and then just the bleeding, which I kept telling her to keep pressure on it because she was losing a lot of blood.
And when you went into the home, you said there was just everything was kind of in like disarray and there was blood, is that correct?
Yes, sir.
Do you remember, was there blood in the bathroom?
Of the bedroom, yes, sir.
In the bedroom, but not in the bathroom?
Yes, in the bedroom. In the bathroom. The bedroom and bathroom connected. There was no door or nothing there.
So you mentioned Mr. Kempton admitted that he had had an argument with the alleged victim. Did he say anything about the knife to you?
Not that I'm aware of, sir.
Did you ask him any questions about the knife?
Yes, sir. Between me and then, I'm not sure which deputy, if it was Deputy Bertram or Deputy Lang, actually had made contact with him first. I know they were both on scene. I know when we kept asking him about what had happened, all we would really get was that they had gotten an argument.
And you said after Mr. Kempton was arrested, he ended up needing medical care. Is that correct?
Yes, per the jail.
And then he went to the hospital?
Yes, sir.
That's all the questions I have.
Hey, you have another witness, Mr. Allen?
Yes, sir. I called it Mr. Morrow, the probation officer.
You raise your right hand, please. Where the testimony about to give is truth, truth, nothing but the truth. You may proceed.
Please state your name for the record and your occupation.
Derek Morrow, unemployed by the Division of Probation and Parole since 2011.
And are you familiar with the defendant, Mr. Kempton, in this case?
I am.
Are you also familiar with the victim, Angela
For
Carroll?
me, I'm aware that she's on supervision, but I never supervised her.
Okay, so you were not her supervising officer.
Correct.
Have you talked to Ms. Guerrero about the incident that occurred?
Have I talked to the victim? No, I've not.
Okay.
But I had a statement forwarded to me from her officer, which may answer your questions earlier.
That's really what I'm trying to find out is who, somebody made a written statement, somewhat detailed. That's the statement that you're talking about.
Yes, it was forwarded to me by Officer Garner, which was her officer at the time.
Oh, what was his?
Jeremy Garner.
Was he an officer there in Wayne County?
No, he is out of District 3, which would be Cumberland and Adair County offices.
Okay. Now, Mr. Kempton was probated in 2023. Has there been other incidents of violation?
Yes, he's had 5 other violation reports submitted while on supervision.
I'm sorry, I didn't understand what you said.
Since starting probation, he's had 5 other violation reports submitted to the court. Totaling, he's got 7 violation reports that have been submitted.
What are the nature of those reports?
His first violation was an admission to the use of alcohol. Next violation, and I'll start with the date, sorry. April 2nd, 2024 was the first violation, use of alcohol. October 14th, 2024, he failed to report contact with law enforcement and failed to report a home address change. In December 27th, 2024, he had a use of methamphetamine. In January 2025, he had a use of methamphetamine admission and a new misdemeanor arrest. In September of 2025, the previously reported misdemeanor arrest was a conviction now. September 16th was sentenced on it. Additionally, that month, he had a drug test that returned diluted. However, we did get another test and it was fine. And then, of course, the violations that are on for revocation today are the new felony charge, use of alcohol, and associating with a convicted felon.
All right. Thank you, sir. Now would you answer the questions of Mr. Rutherford?
I just have one question for you. Were any of the previous violations for violent acts?
The misdemeanor arrest, it started out as harassing communications with some threats. It was later amended down in September to maybe not amended down, but he got a diversion on it. I think the charges stayed the same.
That's one question I have for you.
I have nothing, but thank you.
You have another witness, Mr. Huntley?
We have Officer Lang. Have you heard all this, Officer Lang? Officer Lang? Push the button.
Yes.
All right, thank you.
You raise your right hand, Officer Lang, and swear to testify about the answer truth, the whole truth, nothing but the truth.
Yes.
You may proceed, Mr.
And what is your occupation, sir?
I'm a deputy sheriff with the Wayne County Sheriff's Office.
Were you one of the officers that responded to the incident that we've been discussing here?
Yes.
How did you learn about the incident?
We were dispatched to a possible domestic at that location. I was the third assisting deputy on scene.
All right, did you do any of the paperwork in formulating the charges and the reports?
I did not. That was Deputy Alan Cash. He was the arresting officer.
Do you have anything to add to the testimony that the officers have given here this morning?
Not that I can recall, no.
Was the information and the testimony given by the end of the day truthful as far as you're aware of?
Yes, it was.
That's all I ask. Please answer, Mr. Rizzo.
I have a few questions for you, Deputy. At what time did you arrive at the residence?
I do not have an exact time. I was just the third arriving assisting officer on scene.
So you were the third officer to arrive?
Yes, Deputy Alan Cash was the initial, and then a officer with the police department actually responded as well.
Did you get to see Mr. Kempton when you got there?
I did.
Did he seem irate or upset?
He did not.
Do you recall if he had any injuries?
I do recall he did have a minor cut on his hand.
That's all the questions I have.
Nothing further.
These witnesses be excused.
Yes.
Thank you, witnesses. Y'all may be excused. Miss, you have any witnesses?
I do, Your Honor.
Thank you.
So you raise your right hand, Mr. Kempton. Swear the testimony about to give us the truth, the whole truth, nothing but the truth. Have you been informed by your attorney that you have under the Fifth Amendment of the United States of America a right not to testify in this case? Are you waiving that right?
Yes.
Okay, you may proceed, counsel.
Mr. Kempton, can you tell us what happened that night?
Yes, I came in from work. I had to go to my mom's to change the breaker in the breaker box. Angela left her phone there and we got back to my house. She accused me of stealing her phone, keeping the phone from her. She got a knife and tried to stab me. And I rushed to grab her hand. Instead, I grabbed the knife blade.
So you said that she had a knife and that she threatened to use it on you. Is that correct?
Yes.
And during a conflict with her, you grabbed the knife, and that's how you
Well, why
say.
don't you let him testify rather
Sorry.
than leave him? It'd be more helpful.
I tried to grab her wrist, but instead I grabbed the blade.
And then what occurred after that?
As she ran out, ran to the neighbors. Next thing I knew, the law showed up.
Did you chase her?
No, sir.
So what?
I was in the bathroom washing my hands when the law showed up. Seeing how bad my hand was cut.
And you said, what was the argument about one more time, Mr. Kempton?
When we went to my mother's, she forgot her phone there at my mom's. When we got back home, she thought I was hiding her phone from her. It all went south from there.
That's all the questions I have right now.
Okay. Mr. Hunley, you have any questions?
Did you ever take the knife and put it to her throat?
No, sir, I did not.
You ever had a knife?
I didn't catch that.
Did you ever have the knife?
Yeah, I got it away from him whenever I grabbed it and I threw it outside.
The officer found the knife and you outside, is that right?
No, I was inside when officers knocked on the door.
That's, Judge, I'll have to concede that I don't understand the tenth of what this man is saying. I just don't.
Well, I can understand.
Well,
Would you ask him again? And sir, will you speak more directly into the microphone?
Yes.
Ask him again, Mr. Huntley.
you were drunk, weren't you?
No, sir.
You weren't? You
No.
had anything to drink?
I took maybe 2 shots of liquor that evening.
I'm sorry, you have to speak a little more clearly for me, sir.
I drank maybe 2 shots of liquor that evening.
Now, Judge,
He said he drank 2 shots of liquor.
can you take over? Judge, I'm gonna ask that Mrs. Anderson be allowed to proceed.
Okay, that'd be fine.
I can't hear what the man's saying.
Okay.
Well, I didn't know this. Yes.
We'll pass this witness, Chairman.
That's a witness.
Yes.
I just have a couple of questions for him.
Yeah.
Did you go to the hospital for your injuries?
Yes, sir.
And what did the doctor say at the hospital? What kind of injuries did you
You
sustain?
can't ask him what the doctor said at the hospital.
So what injury did you sustain, Mr. Kempton?
When I grabbed the knife blade, it cut all 4 of my fingers right in the road. They had to glue them back.
And what did they have to do to treat that injury?
They glued them.
And that's it, Your Honor.
Hey, y'all have any more questions? Okay, you have any other witnesses?
No, Your Honor.
Commonwealth want to make an argument now?
A lot of testimony pretty well speaks for itself. Viewing it at its most minor, you have Mr. Kempton in the presence of a convicted felon with no permission from any of the probation officers involved. But looking at it as it actually happened, it like have a very violent incident. And the officers, I think, outlined it in more detail than I will do. I'm going to let the evidence speak for itself.
What is the defense of?
Yeah. You know, I would just say when police officers arrived, he wasn't irate. Seemed like he was compliant. He sustained an injury on his hand that the alleged victim stated he did to himself, his hand, and then he had also stabbed himself on the side. You know, Mr. Kempton or nobody else saw any evidence of another injury to himself where he'd stabbed him. So I would just say, you know,
What
based
do you
on,
have to say about being present with a convicted felon without permission?
yeah, I'm not sure if Mr. Kempton was aware that she was a convicted felon, Your Honor.
Anything else?
No, that's it.
I think there's been more than sufficient evidence to presume to prove that Mr. Kempton was present with a convicted felon and was with an altercation and been drinking alcohol and wasn't a fight there. All those things violate the provisions of his probation, so I'm gonna revoke it. Okay, thank you very much. Joshua Stinson. Are you Joshua Stinson?
Yes.
You here for arraignment? Do you have an attorney?
No.
Okay, I appoint the Office of Public Advocacy. You have a right to remain silent. The grand jury of Clinton County is charged with criminal abuse in the second degree, menacing, terroristic threatening in the third degree, and resisting arrest. And I'm not going to ask you whether you did these things, but I'm going to ask you if you understand those charges.
Yes.
Counselor, do you acknowledge the identity of your client and receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Yeah, I'm going to set this for a negotiation day of February 27th at 9 a.m. Next court date's March 5th at 9 a.m. and you need to do transportation orders for that. I'm signing a reciprocal discovery in this case. Hey, thank you.
Thank you.
Okay, will y'all clear the grand jury area out over here just for a second? The grand jury. Y'all can step back into the conference room back there if you want to. Bring the grand jury, please. Let's go off. Yes.
Having something personal. Water, goes to Deer Park water. In the refrigerator, Deer Park water. Tell them I'm still waiting. Here comes Lord, he'll get it. I think get Deer Park water, they got to pray. Water. They turn the camera on this time. Yeah, right. I need to get one on say something. 47 is going on again. Oh, till then, so we said, I go burn. 40, yeah. I don't know what it's going to be. I hear it 47. That's on breaking. Yeah, Richard Thompson. Probably there, so the it'll be next. These burns all pieces. Thank you. Where can you go? You. Imagine I got one call. Huh? Yeah, you want to sit in here? Yeah. You want to sit in here? I think my lights are coming on again. They put it on break. There you go, candy on me. What we have on the he had 5 years, didn't he? You let me look down. And then what do you think? I'm going to put it in. Never wrote it. You let me do 5. It's 12 months till 5. I go up the road and once you come to state inmate. You want to come state inmate long. At least they revoked it. Yeah. I bet you still get in trouble too because she's got a parole violation because she's supposed to felon. Did you hear it? Yeah. Because he was felon. She was felon. And they didn't have supervisors. They didn't have permission, did they? No. They broke her probation. You heard that? Mm-hmm. Wonder why if he turned this off. She won't be back today. You reckon you get up today? I don't think you will, but you're trying to find a case, can't you? You ain't, we're trying to go rehab. That pick it up today, if I get rid of it. Who are they talking about next? One young?
Richard Thompson in Wayne County, Richard Thompson. Are you Richard Thompson?
Yes, sir.
Step back away from the camera a little bit so it gets your face, or somebody needs to tilt the camera up a little bit, maybe. This is a motion. This is 25 CR 0029. A motion for shock probation, Mr. Cross.
Your Honor, we noticed this remark.
Okay.
Thought we might have better chances at
And
preparing.
we'll continue this motion until March. Your attorney, Mr. Thompson, says that he feels like that you have a better chance of prevailing for shock probation if this is heard. So it'll be heard on March the 5th. Now, can we get Kimberly Elmore? I guess that finished the men there. Your attorney will be able to see you, Mr. Thompson, okay? Are you Kimberly Elmore?
Yes, sir.
Lady, were you born in 1988?
Yes, sir.
4-digit social security number 1247.
Yes, sir.
This is 25 CR 0073, a motion for probation revocation. What's the combo of that?
Your Honor, Miss Elmore has a 7-year sentence on trafficking. It was probated for 5 years. She was supposed to go to the Liberty Place for Women on January the 20th of 26. She stayed there 3 days. She was caught with a pill bottle in her jacket. It had 7 different types of medication. Some of the medication had been nibbled upon. And so she was terminated 3 days later. Since she's been in Wayne County Jail, I've talked to the nurse. They've at Wayne County Jail, I've got her prepared to testify, and she basically says since they took her off 2 of the types of medication, she's doing really well. She can actually converse and form thoughts, unlike before. And if you recall, she was the lady that when she entered her plea, Mr. Poindexter was representing her, and you thought she was under the influence then. They went and got her pill bottles out, and she's probably been over medicated and abusing her prescription medication the whole time.
What do you have to say for Ms. Elmore?
Your Honor,
Get behind the microphone.
I apologize. Yeah, Your Honor, I know initially Mr. Poindexter was representing her and he withdrew, but I have not had a chance to speak with Ms. Elmore.
What do you think? Do you think there's any possibility of getting any kind of treatment or anything?
We can explore that in the next 30 days. I think since the nurse has helped her up at the Wayne County Jail, if she will go with what she's doing there, she might have a hope of succeeding in life.
Well, let's just pass this to March the 5th with the hopes that we can work something through for you, Ms. Elmore. You need to work with that nurse there and be very candid with her about what you've been through and what you're doing, and see if we can talk to you, and maybe we won't have to revoke you, okay?
Ms. Simpson can be excused. She's the nurse on line.
Ms. Simpson, you may be excused. Thank you. Thank you for your work, Ms. Simpson. I know it's a difficult job being a nurse in a correctional institution. Okay, that concludes Wayne County. Y'all have anybody else for us? If not,
That's it.
Y'all can be excused. We're gonna take a short break and then we'll take up Clinton County. Clinton County, if you'll be prepared, be about 4 minutes. We got, Robert Hurt. Bring Robert Hurt out. Commonwealth versus Robert Hurt. Which is 25 CR 0116. Mr. Hurt, we previously identified you in this case. What does the Commonwealth have to say?
We have a felon plea.
Mr. Hurt, a motion's been tendered. We started this far ago. It says you wish to enter guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You the same person that we identified a few minutes ago in 25 CR 0116?
Yes, sir.
Is your judgment impaired today?
No, sir.
You discuss this matter with your attorney. Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? Believe you're fully informed about your case?
Yes,
You
sir.
understand you do not have to enter guilty plea today. You have certain rights. Are we back on? Okay. You have certain rights under the Kentucky United States Constitution. And I need to go over those rights. At the end, I'll ask you to understand. Okay? You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor, right to appeal this matter to a higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that by entering a plea of guilty, you give up all those rights.
Yes, sir.
And then, I may consider the Commonwealth's recommendation, but I may apply a range of sense provided law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that?
Yes, sir.
Who will give the Commonwealth's recommendation? You step to the left there, sir, a little bit there. Go ahead.
Your Honor, Mr. Hurt will plead guilty to possession of controlled substance first degree, receive a sentence of a year. He'll plead guilty to 3 counts of theft by unlawful taking over $1,000, receive 5 years each after a total of 15 years. They'll be run consecutively. Will also plead guilty to criminal mischief first degree, 3 counts, receive a sentence of 5 years on each count and run consecutive for a total of 15 years. All 3 sentences shall run concurrently for a total of 15 years. You'll serve 210 days in jail with the balance probated 5 years. Supervision shall continue until all restitution is paid in full. He'll enter and complete a long-term treatment facility agreed to by his counsel in Commonwealth. After he serves the 210 days, he'll remain in incarceration of the service of the 210 days. And in the morning of the bed date, he shall be transported to the rehab facility by probation and parole. He'll owe restitution of $26,022.15. And that'll be paid at $200 a month. Once he's at rehab or released thereafter, whatever Mr. Hurt desires, first restitution and be $200 each month thereafter. Probation shall continue until all restitution is paid in full. He'll receive credit for time served and pay court costs at discretion of the court.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictments as amended? Doing so of your own free will?
Yes, sir.
Well, your constitutional rights explained to it is still your desire to give up those rights and plead guilty to charges and other court fix your punishment in range permitted by law. Is that correct?
Yes, sir.
You understand that during this guilty plea today, any future convictions can be enhanced for your range of penalty and persistent felony offender law. You understand that?
Yes, sir.
Is that your signature?
Yes, sir.
All right, accept the agreement, order of pre-sentence investigation for scheduled sentencing for March.
Your Honor, could we address that? He is asking if we could delay sentencing so that he stays at this local jail rather than being sent to another jail for 45 days. Could he be sentenced in April?
No.
Okay.
Okay, and the reason is because he is a county prisoner, right?
He'll be a county prisoner until sentenced.
Just sentence. you know,
He just wanted me to ask.
I understand. Yeah, I thought.
I was just trying to serve him a moment.
Okay. March 5th or since. Thank you.
All right, thank you, Your Honor. That's all I have. Can I be excused?
Absolutely.
Thanks, sir.
Yeah. Okay, let's go to the Clinton County Jail. Clinton County Jail. Let's talk to Daniel Anderson. Daniel, are you Daniel Anderson?
Yes, sir.
Good morning, Mr. Anderson. We're here on 25 CR 0055 and 25 CR 00113. Were you born in 1988, Mr. Anderson?
Yes, sir.
Last four digits, social security 1882.
Yes, sir.
Okay. On June the 18th, an order granting pretrial diversion was granted. The Commonwealth recommended a sentence of 2 years diverted on January the 8th, 2026. The pretrial diversion was voided. Therefore, in the other case, the Commonwealth recommended a sentence of 5 years to run concurrently for a total of 5 years and probated and 5 years supervised. We finished pay restitution in that case. So we had 25 CR 0055, which was the pretrial diversion that was revoked, and 25 CR 00113. It appears, were those running concurrently consecutively?
I think they had to run the second statute.
Yeah, I think that's true. I didn't see it in here.
And I think it's been accepted in the special.
He has been, yeah.
Okay, well, we'll go ahead and enter the judgment here, and then are you gonna shock probate him into that or what?
Well, I had in there, my recommendation, he would serve a alternate sentence, serve so many days, and then go into the road.
It's 90 days from today.
See, I didn't quite understand that because of the other one that had been revoked.
And I'm recommending, I guess, probation on that, even with a revocation on the first.
Okay, so we probate that one. Run them consecutively, probate that one. Okay. You shall pay restitution in the amount of $100 a month to Silico Goodman, with the first payment due on before June the 11th, 2026. That's consecutive to 5/5. Okay?
Thank you.
Thank you very much. Well, I understood that. Eddie Bowman. Eddie Bowman. Are you Eddie Bowman?
Yes, sir.
Good morning. This is 26 CR 0002. Are you here for arraignment? You have an attorney present here. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with criminal abuse in the first degree and being a persistent felony offender on criminal abuse in first degree. Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, interplead not guilty, reserve all pretrial motions.
I do, Your Honor.
Okay, we'll set a negotiation day on February 27th at 9 a.m. The next court date is March the 5th at 9 a.m. and I'm signing a reciprocal discovery order that requires the Commonwealth to provide you with the information to prepare for your defense. There's a motion to increase bond here. What do you have?
Your Honor, I filed that, I didn't know if the court was gonna keep the probation holder in effect or not. I filed that. I received additional information after I spoke with the child's mother, who was a co-defendant in the previous case with Mr. Bowman, and also the social services.
and I learned more information. I wanted to make sure that Mr. Bowman didn't have any contact with the child while this case is being, until there's a resolution that.
Judge, and me and Mr. Stockton have talked about, I think your bond, your original bond conditions prohibited him from having any contact and also placed him on ankle monitor. So I don't believe they're already met.
Yeah, and
I would like the court to consider.
No bond on the probation violation. What was he on probation?
he's on probation for criminal abuse, 2nd degree, where he pled guilty to abusing the same child as the victim in this case.
Well, you'll need to have a hearing on this. No, I mean,
I'm sorry, Judge, I wasn't.
you'll need to have a hearing on it. I'm not gonna, if I've got somebody out on probation and they get charged with having this contact with the same child again, I wanna know more about it.
And I guess my question is, do you want me to go ahead and proceed with the revocation of Commonwealth?
I'd rather let's try the case,
Okay.
or you can work some agreement out to go.
We had agreed to hold it in abeyance pending the resolution of this case. And
Well, you need to take a look at this case. I don't know whether I'm really gonna hold it in abeyance or not. You know, I want y'all to talk about this case. Negotiation date is February the 27th, and the next court date is March the 5th, and you need to prepare a transportation. You need to prepare a transportation.
Judge, I do have a conflict with the 27th.
Well, you can work out a different date for the Commonwealth.
Okay. All right, Judge.
Okay, thank you. Your attorney will be over to talk to you, sir. Luther Connor. Raymond. Commonwealth versus Luther Connor. Mr. Connor, I'm going to appoint public advocacy to represent you. Commonwealth versus Luther Connor, 26R0001. You're here for arraignment, Mr. Connor. You need to have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with strangulation in the 1st degree, assault in the 4th degree, theft, unlawful taking or disposition, theft of a legend drug, theft, unlawful taking or disposition, being a persistent felony offender on strangulation, being a persistent felony offender on theft, being a persistent felony offender on theft of a legend drug, and being a persistent felony offender 2nd degree on theft, unlawful taking or disposition. Counselor, you acknowledge the identity of your client, received indictment, waive formal reading arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order, Mr. Connor, requires the Commonwealth to present you the evidence they have helped you prepare for your defense, scheduling a negotiation day on February 27th, and the next court day is on March 5th, and you'll need to do a transportation order, Mr. Connor. Okay? Your attorney will be down to talk to you, Mr. Connor. Thank you.
Thank you.
Matthew Crutchfield. Are you Matthew Crutchfield?
Yes, Your Honor.
Good morning. This is CR 0033 for probation revocation and 25 CR 0089 for pretrial diversion revocation. This is, were you born in 1997?
Yes, Your Honor.
The last 4 digits, social security number 0195.
Yes, Your Honor.
Now, I'm kind of interested to know how we had a pretrial diversion. It was a misdemeanor probation, okay.
Yeah, that's the reason he first denied on the 25 CR 33, he denied that he had any kind of drug problem at all. So I took him at his word and did a misdemeanor. Then it wasn't long till he was indicted again on possession, and we did the diversion. And he's had some drug tests. He went to CTS in Louisville and left after 8 days at rehab and didn't report when he got back. So I think he's gonna stipulate.
Okay, well, I will revoke the pretrial diversion, order pre-sentence investigation court gun, have probation and parole and schedule sentencing for March the 5th, okay? Yeah, and we'll revoke the probation on the misdemeanor. But we'll do that. We can do any kind of change of sentencing on that we want to on this. Okay, thank you very much. Billy Davis Jr. Billy Davis Jr. This is 25 CR 0071. Are you Billy Davis Jr.? Are you Billy Davis Jr.?
Yes, sir.
Good morning. Were you born in 1970?
Yes, sir.
Last 4 digits, social security number 1524. Is that correct?
Yes, sir.
Okay, we're going to probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Davis has 2 positive for meth for this month. He was supposed to contact SAP IOP and go through Adana for that. He never contacted them. And then he's got a criminal trespass from January the 25th to 26th. He's wanting specialty court, and I'm gonna reluctantly agree to it if the court wants to.
You want to not revoke him and put him in special?
Well, he's in, yeah, I'm gonna give him a chance. He's not gonna last very long.
Okay, well, what I'm gonna do is I'm gonna hold a probation revocation in abeyance. I'm not gonna deny it. So we'll waive these things that he's done, and it can have a cumulative effect if he does anything else. Counselor, you understand that?
I did understand that.
Okay. Well, they're gonna do a referral to you, on specialty court. Mr. Davis, are you ready to try to work on that? Turn your life around a little bit?
Yes, sir.
Okay, well, the Commonwealth's gonna give you that chance, so they'll be down to interview you, see if you qualify for specialty court. I'm gonna hold the things you've done in violation here in abeyance, and if you have another violation, we'll pile them on top of it. You understand what I'm saying?
Yes, sir.
Okay, thank you. Nicholas Purdue. Commonwealth versus Nicholas Purdue. Are you Nicholas Purdue?
Yes.
Good morning. This is 25 CR 0061. We're here on a probation revocation. You born in 1992, Mr. Purdue?
Yes.
The last 4 digits are 7862.
Yes.
Okay, what's the comment have to say?
Your Honor, this is a similar case. He's got 3-year sentence on possession of controlled substance first. He has 3 positive tests for meth since October of last year. And he didn't go to treatment as requested by the SSC. I'm willing to also get him in specialty court if he wants to do that.
Mr. Purdue, you want to try specialty court, drug court, see if you can make it?
Yes.
Okay, well, this is your chance. I'm not gonna rule on these revocation motions, so I'm gonna hold that in abeyance. So if you do anything else, it'll pile up on you, okay?
Okay.
Okay, they'll be down to interview you.
Thank you.
Yeah. Jimmy Pointer. Jimmy Pointer.
Yes, sir.
Jimmy Pointer. This is 25 CR 0008. Mr. Pointer, were you born in 1986?
Yes, sir.
Last 4 digits, social security number 8306.
Yes, sir.
Okay, we're here on probation revocation. What does the Commonwealth have to say?
Mr. Pointer was in the specialty court program and was terminated. My understanding is he's going to stipulate.
Yeah, I will revoke the probation. Okay. Your attorney will be down to see you, Mr. Pointer, okay?
All right, thank you.
William Willis.
Thank you.
Are you William Willis?
Yes, Your Honor.
Morning, this is 24 CR 0014 and 15 and 26 CR 0008 for the purpose of arraignment. You have the right to remain silent during arraignment. The grand jury of your attorney is here. The grand jury of Clinton County is returning an indictment for illegal taking or pursuit of a deer, 14 counts. Tampering with physical evidence, 14 counts. Mr. Cross, you acknowledge the identity of your client receiving that away formal reading and arraignment and pleading not guilty to joining all pre-trial motions.
Yes, Your Honor.
Is this a companion case with someone else?
We're very Willis. We're both.
Okay.
But Mr. Willis also has revocation motion on, and what we're doing, Your Honor, is try to get him in drug court. That's why we passed it.
Well, I'm gonna do this first here. Mr. Willis will have a sign a reciprocal discovery order where the Commonwealth will give your attorney information to help prepare for the defense. Now, what do you say, Mr. Stockton, on this?
Yeah, we've had him assessed for drug court, and I think he's been accepted. So as soon as they're ready to orient him, I don't care to release him on that part of it, and then I can negotiate with Mr. Cross and Mr. Rutherford on the deer case.
Well, your case is felony.
Well, the taking of the deer is not, but moving the deer is the tampering case.
Yeah.
So I've been, and it may go back, I don't know, I don't want to comment on it. I've got my own feelings.
And I do as well. Let's just say that Mr. Stockton and I have had productive discussions.
So I don't know what's going to happen, and I want to explore somebody responsible for it.
Well, productive discussions, kind of like productive cough. People look at the production a little different.
But I don't have any objection to him going to start state.
Okay, so he'll be interviewed for the specialty court.
He has been.
Yeah, I
And
think
then accepted, been voted in, so you do the orientation. Mr. Willis, you're gonna get a chance here if you go in the drug court and perform well to advance yourself. You think you're ready to do that and turn your life around a little bit, man?
Absolutely.
Okay, well, you're gonna get a shot at it. So they'll be down at Oregon. As soon as they orient you, I will sign a release form, get you out of jail and maybe get you back to work, okay?
I know the first question he's got is when that will be. Do we have any
I
idea?
don't know.
Because it's been pending for some, we'll find out. I'll talk to him. I'll talk to
Robert
Barry and I'll
Wright,
talk-
Robert,
Maybe an issue because of the release of this being held on the revocations with no bond. So drug court doesn't contact me anymore about releasing them. I don't know how they get
I'll
released.
talk to Barry.
Yeah, but I don't know how that will work with the VA, I don't know that. Well, I'll get an order of revocation on that. Okay. There's already drug court, so that should take that out, right?
we'll sign it. It's a mystery here, though, right? Maybe we don't want to know. Robert Wright, are you Robert Wright?
Yes, Your Honor.
Morning, Mr. Wright. We're here
Morning.
on 25 CR 0072 for sentencing. Were you born in 1981?
Yes, Your Honor.
That's 4 digits of your social security are 6136.
Yes, Your Honor.
We had an opportunity to look at the pre-sentence investigation report done by probation and parole. Have you gone over this
Yes,
with?
yes, I have. It was on my laptop. That's what it was on my laptop.
Yeah, is it substantially correct, counsel?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Following defendant's plea of guilty, the possession of controlled substance, first degree, first offense, methamphetamine, offense shall receive a sentence of 3 years probated for 5 years supervised. He shall enter and complete IOP and be released at final sentencing. Now, is there court cost?
155.
$155 court cost. You need some time to pay that. I'll let you pay the $50 a month, the first payment due at 1 month from today, okay?
Yes, Your Honor.
Okay. And you'll be released, and then when does he become probation parole officer?
I'll be down to the jail to see him in about 30 minutes.
He'll be down, the probation parole officer will be down there in 30 minutes, that way you won't have to reschedule, and then we'll sign a release order and get out right after that, okay?
Yes, Your Honor.
Thank you very much. Do you have something?
I've got one that was expedited for Norris Nagel.
Okay. That includes the rest of the docket, right?
Yeah.
Commonwealth of Kentucky versus Norris Jean Nagel. Where is Mr. Nagel? Are you Mr. Nagel?
Yes, Your Honor.
Okay, Mr. Nagel, what's your year of birth? 1983?
85, sir.
That needs to be changed. With permission, we'll modify that in front of the indictment. 1985. Last four digits, social security number 6121.
Yes, Your Honor.
For the purpose of arraignment. You have counsel here. The grand jury of Clinton County has returned an indictment charging you with trafficking in cocaine in possession of drug paraphernalia. Also with possession of a controlled substance, first degree cocaine, and tampering with physical agents. You understand what those charges are? I'm not asking for you to do it. You understand what the charges are? Counselor, do you acknowledge the identity of your client receiving that waive formal reading and arraignment, interplead not guilty, reserving all pretrial motions?
I do, Your Honor.
Okay, well, we'll schedule a conference on the 27th of February, and the next court date is on March 5th.
And Judge, can we discuss his bond? He had a
If you like.
Yeah, he had a $5,000 cash bond in April when this was allegedly committed.
In district court?
In district court. His wife got cancer post, I think that same month, they moved to Florida to be with her family, so there was more support. I think the indictment was issued sometime in June. I think the Commonwealth would be agreeable to a $10,000.
Did he come back?
No, he didn't know that he was
He wanted
indicted.
extradition, I think.
He was.
Had to finish up those charges.
And I think that
Anyway, they just.
Commonwealth's
Wait,
okay.
did he have charges in Florida?
I think it was,
So he was in custody.
Are you standing up to be recognized, or you just?
I'm just stretching, Judge.
I think he was pulled over.
And had a
But I-
warrant, outstanding warrant?
Yes. And I think the
Well,
Commonwealth is.
Are you going to look into it a little bit?
I don't mind if somebody wants to post a $10,000 cash bond and he'll end up having to pay his transportation fee anyway, I won't have any objection to it.
What was the transportation cost?
I don't know right off. Probably a couple $1,000.
Well, what we need to do is come up with a transportation cost. If he puts transportation cost in a $10,000 cash bond, no property. Cash.
And he's
bond.
already got 5 posted, so.
Well, 5 more, you know.
Yes,
I mean,
absolutely.
you're all for that, aren't you?
Yes.
Yeah, I thought you would be. I would be. So, in addition to that, I want him to sign a waiver of extradition. Sir, will you sign a waiver of extradition? You've already waived extradition once. They'll bring it down there and let you sign it at the jail, okay? Will you do that?
Yes, Your Honor.
And, you know, we don't have to send the dog after you.
I'm so sorry. My wife's battling breast cancer. I do apologize, sir. I didn't know.
I'm sorry she has cancer, and I hope it turns out well. I know it's a difficult time, but don't make it more difficult, okay? Okay, that'll be it.
Thank you, Judge.
Okay, thank you. Does anybody else enter to jail on the docket? Not
No,
that
sir.
completes the criminal session of Clinton Circuit Court with 5 minutes to spare.
Back there.
have fun. Well, let's come to order here. Let's do the child support docket. Those that are owed child support are going to benefit from the improved mood of our county attorney because of the way his wildcats are doing.
That's right, that's right. They've improved it a little bit, so.
Callan versus Fairchild.
Judge, I need to put Stephanie, bring Stephanie here under oath, so her testifies to the motion.
You swear the testimony best gives the truth, the whole truth, and nothing but.
I do.
State your name,
Stephanie Witham,
by whom are you employed,
Clinton County Child Support,
and what is your position?
case worker.
Are you familiar with the case we're going to today involving Callan versus Fairchild?
Yes,
And are you asking that the child support amount be decreased in this case?
yes.
Okay, and what is the basis for that?
It was a state ordered review.
Okay, and was the, what information did you receive?
We based Miss Fairchild at minimum wage.
Okay, and what amount are you asking that the child support be set at?
$312 per month.
Is there any opposition to that?
No opposition.
Submit the order. Heiser versus Heiser,
This is also Stephanie,
still under oath.
Your name, Stephanie. Ms. Whitman, are you familiar with the case we're in today involving Fuller versus Heiser?
Yes,
Okay, and what motion is child support filed in this?
a motion to decrease.
And what is the basis for this motion?
The NCP requested the review.
Okay, based upon the review, what was the findings based upon the child support guidelines?
A decrease to $337 per month.
Has an order been submitted?
Yes.
Before?
Okay, look, any opposition to this? Appears to be no one in the opposition. Submit the orders. Cabinet versus Omeda.
Great order has been submitted on that case, Judge.
Thank you. Check that, include the docket.
One more, we have Armstrong versus Catron.
It may.
It may not have made it, Judge.
No, it's on.
Cabinet versus Catherine.
What's your involvement in this case?
I'm the caseworker.
Are you familiar with this case, Armstrong versus Catron?
Yes,
Okay, and what's the motion in this case?
it was a state ordered review.
Okay, and based upon this review, what were your findings?
It's a motion to increase to $199 per month.
Okay, is that based upon the Kentucky Child Support Guidelines?
Yes.
Okay, submit the order. Okay, we're a little early on the 1:30. Oh, we got EPO at 1:15, looks like. Dalton versus Dalton.
Mr. Gibson's back there somewhere. With the respondent.
See somebody in the back, please? Somebody in the back.
Do I have to file on this? Okay, we have Ross, Morgan Dalton, and Amanda Elizabeth Dalton. And we have a domestic violence situation. I don't have a copy of it.
Need to petition your own.
Send it across the hall, right? Okay, you want this, does your client want this to continue? Or-
Yes. We haven't had an opportunity to talk to Mr. Gibson to see if we could come to some sort of an agreement.
Are these two parties going to get in a divorce now? Are they?
Yes, we have a divorce file here. And Mr. Gibson did enter an appearance, and we've had only limited discussions.
I just looked like it was just a threat to damage the house.
Well, my client would, that's not the way I read the petition.
I'd have said something like breaking windows out or something, I don't know. You read it again.
She's prepared to testify, that's what we need to get into.
Well. I don't see, I still. It had pictures of where she has attacked me. She doesn't say when the attack took place or anything, and she talked about she was gonna bust the windows out. He's afraid she might do something to the children. Because
As I say,
of
Your
some
Honor,
cleaning lane.
He's prepared to testify as to the history. I understand what you read there. But it's entitled to flesh it out.
Yeah, here, how many children are involved? Three children, and they're getting a divorce. Is he living in the residence now?
He's living here in Clinton County, she's living in Cook.
Was the marital residence here in Clinton County? She's gone to Cook, and the kids are here.
Yes, at this point.
What are y'all willing to do on this?
We haven't talked with him yet. I'd be happy to talk with him.
Why don't y'all go back there and talk with me and see what kind of.
Okay, thank
Now,
you.
is there a lot of property gonna be involved in this?
Potentially, but
Shall I go back over there
we
and
could
talk?
settle it in 5 minutes, or it could take 5 months. That's the way I look at it. Just
Let's go over there and, no, I wanna keep that open over there. Okay.
There you go. You want to take the final? Take it bigger than that. Let's be.
Okay. Still a little early on the civil docket. In the case of Mitchell versus Mitchell, are the parties here? Okay. Mr. Cross, we'll have to come back to it because Mr. Cross is involved.
Yeah, I think it's Mr. Gibson and.
Well, Mr. Gibson's back there too.
Oh.
Shelton versus Storch.
Mr. Cross is on that one too, you're on.
Okay. Owens versus the medical center.
Good afternoon, Your Honor.
Hello.
Barry on behalf of the defendants.
Afternoon, Your Honor.
Mr. Carroll, I haven't seen you in a while. Good to see you.
Always good to be in Clinton County.
Yeah,
Feel the same way.
never been here before, but I like it.
You won't like it too much.
Nice drive. Your Honor, this is defendant's motion for in-camera review and to reconsider. This all comes back to the motion to compel two documents that we have tendered under seal for you to review in camera. Plaintiff's response, he indicated that he has no objection to an in-camera review. So ultimately, upon this review,
We're hoping that the court will have the opportunity to evaluate the two documents and see that they were prepared for purpose of reporting to a PSO for the improvement of patient care, and that the documents include root cause analysis, making them fall under the patient safety work product.
Your Honor, I think the court made the correct ruling for the first time,
First time ever?
No, in its first ruling. I also did not have an objection for the court to review these two documents. The case which they cited, a really new case out of the Supreme Court, very clearly says the incident report is discoverable.
You
And it
agree with
wasn't.
that? You agree with that? The new county, what's the title?
So it's Baptist Healthcare. I have a copy of it if you will.
Yeah, it's in the binder.
Yes, we attached it to our motion,
Yeah,
but I do have a copy if
you don't agree it says that.
So we agree that it does say that the incident report in that scenario is discoverable. However,
You distinguish it.
yes, Your Honor, we distinguish it. What we have is a fall summary event report in a fall huddle form, which are not solely factual documents like the incident report in the Baptist Health cases.
In the Baptist Health case, the incident report was prepared the same day. This case, not only was it the incident report, the nurse who prepared it said it was to be both the medical record and the incident report all in the same document. It was to serve the same purpose. And the only possible purpose of calling it an incident report was to keep it from being discoverable. As to the fall huddle report, which we don't get to see under the camera, it is only protected if it does a root cause analysis, which the Supreme Court describes as a retrospective review to analyze errors, determine what was the cause, and the practices to improve that. The discovery we did was basically that they prepare this and send it off to somewhere to store it. And from the testimony, did not appear that it meets the requirements of the root cause analysis that the Baptist healthcare case says. So I think the court made the correct decision, but I certainly would not have any objection for the court to looking at it. And I think the correct ruling would be to reaffirm its original ruling.
No, I don't have any objection to looking at it. No. How are you gonna provide that to me?
I believe it was already provided under seal. It was tendered under seal. If that is not the case.
Yeah, it would have been to the clerk and I wouldn't have been aware of that.
Okay, I will make sure that it gets to you.
You're welcome to send me a copy as well.
It's like.
Okay. Well, we'll look at it. Now, if it's unlikely that I'll change my opinion, as you know, about it. Where are we in the case of the other discovery? Will you think that this might generate some need for additional discovery if you get it, or what are you thinking?
I really don't know, Judge, until I get it. We have taken some of the depositions. I think we have about one or two more left to take that we know about. And at that time, it'll be time to start disclosing expert witnesses.
Did y'all try mediation in this thing at all?
We have not, Judge.
How do y'all feel about that? Do you have any authority to?
I do not have any authority as of right now to commit to mediation, but from my just knowledge of this case, I don't think we would be objectionable to mediation.
Yeah. Why don't you run it up the flagpole, as they used to say, and check about that, and then make some arrangement for me to look at this. I'll just tell you up front, I don't have a lot of experience in these sort of things. This was not my forte, as they used to say. but I'll be glad to look at the thing, but I guess what you'll need to do without the objection, Mr. Carroll, is when you submit these things, it wouldn't be inappropriate, I don't think, for you to call my attention to things that you think would make you prevail on things. Now, that's kind of an ex parte sort of thing if you don't watch it. But how would you, I really don't think it's gonna do any good very much. I can see what you argue to look at it, but how does it work? You ever had judges want to do that, to have some explanation as to why they thought the in-camera?
None other than what has already been presented in the
briefs?
In the briefs.
Yeah.
You think that'll be sufficient, is what you're saying?
Yes.
You know, I gave you the opportunity to talk to me about it on the side, you just rejected it, so, just kidding. Okay, well, you.
Can't joke with me like that. I'm your attorney.
Okay, well, you just send it to us and make sure that.
Yes.
My staff lawyer gets it, and she'll probably do it in camera first, and she and I'll look at it together.
Okay.
Okay, thank you very much.
Thank you.
Safe journey, both.
Thank you.
Ryder versus Crescent Ridge property owners. Still a little early. 5 minutes early. Ryder versus Crescent Hill Ridge property owners. Talent versus Out Corporate Equipment Sales. Who's on?
Afternoon, Your Honor. Nathan Allen on behalf of the defendant, and I see attorney for the plaintiff, I believe, is on the screen here.
Good afternoon, Your Honor. Brandon Chandler here on
There's
behalf
a
of the
green
plaintiff.
screen going on there, don't you? Got your green screen.
Your Honor, we're here for my motion for leave to file a third-party complaint, and I want to be clear, that's all I'm asking for today. I'm not asking for a ruling that anybody is or is not entitled to indemnity. I think you've probably read our briefs, and we've set forth a prima facie case for indemnity that shows that we're at least entitled to file a third-party complaint. And so if you have any questions about that, I'm happy to answer them, but I'll turn it over to you.
What's the response on a third-party complaint?
We stand opposed to the defendant's motion to the extent just that it asserts a right to pursue an apportionment instruction for Wolf River. As far as indemnity and contribution are concerned, we don't have an objection. We still believe that workers' compensation is an exclusive remedy, but we don't have an objection today for indemnity.
Well, if you get down to the point where you have jury instructions.
Sorry, would you say that again?
If you get down to the point, if we get down to the point in this case, we're about to submit it to the jury and we have jury instructions. Then they would be, if they make it that far and you're not correct about workers' comp being an exclusive remedy, then it would appear to me that if they aren't a party to the thing, that you would have some difficulty in instruction at that juncture to find out what indemnification was available. Is that right?
I agree with that. Yes.
What do you have to say about that?
As far as indemnity and contribution are concerned, that's not our fight. Our fight is just about apportionment, which is always available. It does not have to be asserted in a complaint as a count to be available in a tort action. It is always available to the defendant in tort action.
Well, it would appear to me, though, if you didn't know something about what kind of workers' comp award had been done or something, that apportionment. So you don't, well, let me just think about that. I really never have, this is a situation of first impression for me. I never have dealt with a situation. I didn't do workers' comp. And usually cases like this are settled, was my experience. Have y'all gotten into, you know, I could go ahead and let the complaint, a third-party complaint be filed, and then we could strike it at some time later. I could hold it. I'm inclined to allow them to file a complaint. And it won't prejudice anybody at this juncture to file it. that much. So I think I'm probably gonna let it be filed, okay?
Our suggestion, if you don't mind, Your Honor, our suggestion would be to allow the defendant to tender a proposed complaint that removes the apportionment count. That's our only gripe.
How do you feel about that?
Well, I disagree. First of all, and Brennan, correct me if I'm wrong here. I thought your response was objecting to the indemnity parts, and then just saying the apportionment is proper and they would be treated as if they were a settling party. And so then when it comes to jury instructions, whether or not they're a party to this case, they're going to be treated as if they had settled by way of the workers' compensation. So they could still be apportioned fault later. That just wouldn't be money.
See, I was a little familiar with the apportionment workers' comp sort of situation, but the indemnity thing kind of throws me off a little bit, just to tell you the truth.
And so there's two parts to that. There's what we believe is common law indemnity, to the extent that we believe they are more at fault than us and we're not in par delicto. And so that, you know, Wolf River should be responsible for anything that we are deemed liable for. We can turn around and recover it from them by way of a third-party complaint. The second point there, though, and I think this is the stronger argument, is contractual indemnity. And you saw in my brief there that there's pretty strong language, strict language that describes situations exactly like this one, including wrongful death like this one, where they have a contractual obligation to indemnify us and defend us. And so not only are we going to turn around.
You own the equipment, right?
Truthfully, I don't know the answer to that. I'm not sure if we rented it or if we owned it. I'm kind of just jumping into this case. I don't think that's particularly important today. But yes, my company rented the equipment to Wolf River. And so they signed a lease agreement and they agreed to indemnify.
Here's the thing about it. Do you think that contractual, that it's against public policy to enter into contracts that would completely prohibit a renter or owner of equipment from having any liability if there was some flaw found or some serious maintenance problem? If that's true, there would never be any lawsuits against equipment owners because everybody would have that sort of clause in their agreement.
Fair enough.
Did you call those adhesion clauses?
The contract of adhesion is how I was taught in law school. Fair enough. I don't think that the language in our lease agreement here rises to that level. What it says here.
Good position to take.
It is beneficial to me, at least today. It says risks associated with the possession, use, transportation, and storage of the equipment. And then there's a period at the end of that sentence. So that's not including product liability.
There hadn't been any discovery that indicates that there was some kind of problem with the equipment itself. It's purely the operation. Is that right?
Correct. We are alleging misuse here, and that Wolf River should indemnify and defend us from that claim. And they need to be a party to do that if they're going to defend us. And so again, I don't want to get too far into the weeds here because we're not asking you to make a ruling on whether or not we're entitled to indemnity. That's going to be up to the jury.
Go ahead. I don't think it hurts anything to let the complaint be filed and we'll sort it out. As one of my old law professors used to say, so we'll put it out there and let them labor and Jesus flings them later on. You know what I'm saying?
Okay.
Okay. Well, that's my ruling. And I don't see how any harm is done to anybody by letting it in. We can make rulings on the applicability of indemnity or any of the other issues of the workers' comp claim as far as apportionment. We can do that later.
Okay.
Well, thank y'all very much.
Yep. Thank you.
And I'll go back and review those motions again. I'll have to educate myself. Maybe I'll be a little bit better prepared next time. Okay.
Thank you, Your Honor. There is an order attached to our motion. I've got a copy here if you need it. It was e-filed.
You got it. Okay.
It looks like December 17th.
Okay. Thank you very much.
Yep. Thank you, Your Honor.
Okay.
I'm trying to do the water dams. To create the goal of when the release was filed in 2 days.
Okay. So what do we have left? Mitchell versus Mitchell. You're working on that backyard, and
Good afternoon, Judge.
hello, how are you?
I'm good. How are you?
I'm blessed, thank you. Now, you are Samantha,
Yes.
and where is Cody Thomas Mitchell? Here?
He is represented by Mr. Gibson.
Mitchell versus Mitchell. What we got here?
We're just asking for a hearing date on his petition that's been pending for 5 years or whatever time it is.
No reconciliation possible.
I don't think there is yet.
Are you involved in this thing?
Yes, Judge, I was appointed guardian ad litem as well as friend of the court. I believe I'm guardian ad litem in the termination case and friend of the court in the time sharing action.
And you're not represented now?
Yes, that's me, Judge.
I thought you were just greeting me. Okay. Well, have y'all tried to mediate this? All is too far to do.
I don't think it's their position is that he should never have any contact with kids from this point forward. And we were waiting for a custodial evaluation to be completed and then a friend of the court. We actually had a pre-hearing with you something like months back if we wanted to deal with this issue before we went to the termination issue. So
Both of those have been completed, Judge. Both of those have been completed for some time, the custodial evaluation as well as the friend of the court report. And I submitted a supplemental friend of the court report after the custodial evaluation was completed.
Well, refresh me on that. I don't.
A custodial evaluation was requested, I believe, at the request of Ms. Warner's former attorney. It was completed by, I think, Sheldon Forensic.
Tell me what the result.
The results I do have quoted in my supplemental friend of the court.
No, but just tell me real quick what they are.
I don't want to misquote, so let me. It did not appear to be in Mr. Mitchell's favor, the custodial evaluation, essentially.
It's no contact, Judge. The evaluator has determined that it would never be in the children's best interest for he to ever be acclimated to the children's lives. They don't know him in any way, shape, or form. And after we received that custodial evaluation, we have filed the termination case. And so, I mean, essentially, if you hear this case as to whether or not he would have any contact with these children and you determine no, obviously that would be a huge amount of the factors and testimony that we would then ask the court to take judicial notice of and proceed with the termination and adoption by stepfather.
And Judge, I will say, I met with both children and both children said that they have no memory, either good or bad, of the father. They just have no memory of him whatsoever.
Okay. How do you want to proceed?
we want a hearing date on
On which ones of these things, you know, I mean, I guess we could combine.
I would object to that, Judge.
You determine the determination, and this could be combined if the testimony is going to be.
Well, I don't think that would be the best interest of his or the court, Judge. There's already been a termination case that was filed by mom, and you overruled that. Now it's been filed by her husband, and it's involved with it. It's just kind of the same issues involved with it. It's been going on forever. And the rulings from the custodial evaluation actions.
We didn't have a custodial evaluation in other cases.
No.
Not in the termination.
No.
But
Well,
still,
not in, not in the case where she wanted to. Yeah, that's right.
Just in the time sharing.
Yes.
and the results of that and the facts of this case are kind of unprecedented, at least in my career, where you're trying to do a de facto termination of rights in a custody case, which is against the existing statutory law and against the facts. I think we need to have a hearing on that and bring it up.
Okay, well, I'll tell you what I want, if y'all will give me, if council involved in the thing, if I'm gonna set a hearing or a trial date in this thing, I'd like for y'all to reach an agreement on the things that I have to decide that since it's kind of convoluted.
Yes.
Y'all can get together and, you don't have to come back here and do another hearing date. If you get that together and get you want. Yeah, that's probably true. I'm always pushed by my staff lawyer to remind me of the fact that it's a lot easier to schedule things when everybody's here than it is. Yeah. Is this a 1 day thing?
Yes.
I'd say at least take a day, Judge.
Yeah. Or at most take.
And Judge, would I, just as, for scheduling purposes, I will have to obviously have the evaluator from Shelton Forensics. I believe they're in Louisville. If I'm not mistaken, would they be permitted to appear by Zoom?
Yes.
Thank you.
Can y'all be ready for this sometime in April?
I believe so.
Yes, sir.
Judge, do you want me to appear as well, or just these two, counsel?
I believe I would prefer she appear, especially because I think as a friend of the court in this case, she would be potentially subject to examination.
I agree.
Yeah. Congratulations.
I know she's excited.
Sure.
Well, we got a major trial scheduled in the last week of April. We don't really know how that's gonna, rule days because of some of these things people moved around. How about, they don't have court hearings. How about April the 8th?
Judge, I apologize,
Perfect.
I'm not available.
Okay, we can't do it that weekend. What about, they have it here on Tuesday, they have court here on Tuesday.
District court days.
Okay, let's do it. How about May the 15th? I mean, April 15th.
I'm available, yes, sir.
April 15th?
Unfortunately, Your Honor, I have 2 hearings in Casey County, but I could devote my entire next day to this, the 16th. And if we had to hear it,
We got Monroe Rule Day.
sorry.
The 22nd, April 22nd.
Yes, sir.
Yes, sir. Will that be at 9, Your Honor?
Started at 8:30.
Okay. Do you all issue your own scheduling order, Judge, or do you need the move-in to do so?
We don't usually do a schedule.
Okay, yes, sir.
We'll send you a copy of the docket order.
No, I'm good. I just always like to ask.
Do you want us to make a?
Hold on just a second. Hello? Yes, see. Fine. Yes. We are. Nobody told me that. Why they didn't pick race races. What time will it, what time will it? Let's do it, do it 9:30. Yeah, we want to see that. It's from. Okay. Yeah, that'd be great. Okay. Sorry about that.
You want us to make a report for the court on the issues after we.
Yeah, when do you have that by?
Whenever you're available.
10 days, some days, okay. If you're not in court on the thing, we can get on the phone and try to whittle them down a bit. Make sure you serve them on front of the court too, okay? Okay, well, thank y'all very much.
Thank you, Your Honor. That's all I have, if I may be excused.
Yeah.
Have a good afternoon.
What else we have? Shelton versus Storch.
We're about to make an announcement on our other location, Your Honor.
No, I'm calling Stelton versus Storch right now.
Oh, you are. That's our place we want. Whatever.
We might have to go out to the bottom.
No.
Okay, what do we have here?
It is our amended motion to, let's see, to modify the current time sharing schedule and motion, well, I think they already do that close, but just modify the time sharing schedule, Your Honor.
Tell me what you want.
Right, so it was my understanding that there had been some criminal mishaps on Mr. Shelton's part, believe according to.
Tell me what you want, but.
Oh,
first. Then we'll fill it in later. What's the time share now?
Current time share is every other weekend, with, Lucas goes down with that.
I can't hear you.
the child stays with mom in Woodford County, and then every other weekend he goes to dad who lives in Barron County, Your Honor.
And you wanna reduce that?
I think we would, at least until he shows he can complete an anger management course and
What indications are there that he's exhibiting anger about the children? Do you have any proof that you're gonna put on about that, or is just some other activity that's been involved?
I do have a screenshot that my client has provided me, and her mother is here to testify to what she's heard between them communicating and an incident where she was involved to get the child, Your Honor.
Your Honor, this initially was pro se motion filed by the respondent. I want to correct one thing. Ethan has a home in Barron County. He also has a home in Clinton County, so we've still got venue here. He's Clinton County. Ethan had a couple of incidents in district court and circuit court that have involving some disputes, primarily with his father. Everything's been dismissed. I have a copy of the dismissal order from circuit court as well as the one in district court. Circuit court's without prejudice. Our position is, and the proof will be, that at no time were these kids ever around when any of these incidents happened. And there were incidents and disputes, but it was greatly overblown. We don't think there's any basis whatsoever to amend anything. He's not seen these kids since October because she wants to if there's a DVO pending in Woodford County, we've got to go up and have a hearing on that regarding the same thing. And we just
Well,
don't.
I'll hear what you have to say.
Yeah, that's fine.
Just wait till the document.
Absolutely.
Okay.
Ralph and I, Your Honor.
Just make sure I'm going right. What else do we have here?
With Ralph Gibson, I can give you a report, Your Honor.
Yeah.
Amazingly, we have temporary agreement.
The best kind, because all agreements are temporary.
Particularly Mr. Gibson and I, Your
Mr.
Honor,
Gibson,
sometimes we
you'll
don't
come up.
agree too quickly about things.
He doesn't want to get in the same camera frame with you, probably.
Let me kind of recite where we are as I'm going to prepare it, okay? Your Honor, my client filed a domestic violence petition and a divorce. What we've agreed to do is dismiss the DVO and have an agreed temporary mutual restraining order entered between the parties. The only communication between the parties would be through text or parenting app. There would
Let's
be.
do parenting app. I think it's better.
Yeah, okay, that's fine. I do too, but it takes people a little while to figure it out sometimes. There would
Can you
be,
figure it out? Parenting app? Can you figure it out? Well, it's not.
well,
gonna
they're
take-
smarter than me. Okay,
Maybe more technical than you.
fine.
Go ahead.
Anyway, we're not going to address custody at this point in time. We're just going to address parenting time. She's not seen these kids in weeks. We want to avoid any issues. So
How old are they?
they're, let's see,
11, 8, and 9, I believe.
yeah, I've got 11,
8
yeah, close. You're
or
close.
11, 9, and 8.
More than 14, 18, and 19 is what I've got. Your Honor, there will be some supervised visitation for the next 2 Saturdays. We've agreed on an individual who would supervise same. That'll be, what, 6 hours, we said, Ralph? Okay. The next 2 weeks, there would be unsupervised for 6 hours. And if there's no incident, then that would graduate into weekend visitation. If there are incidents.
Are the children gonna be resistant to this?
I think they will be, and one thing I'll go ahead and bring up now, I think it's a good idea to have either a guardian ad litem or a friend of the court. Mr. Gibson's not necessarily on that same
I don't
page.
think, let's just see how it works out first before we start
Fine.
complicating things and getting other people talking to the children and everything, you know. ultimately, unless there's just some drastically damaging things that come out about the mother, you know that she's gonna get significant time with the children. So there's no reason complicating this any more than we have to. Now, what kind of, your client left the marital home and went to Tennessee, is that correct?
They actually both resided in Tennessee for a while. They own a marital home here. They sold.
So they
one.
both went to Tennessee and she stayed and he came back.
He came back with the kids.
That's correct.
And then filed it. So we're just so clear, we're not saying that either one of them are at fault because of the issues with the kids. We just know that she's been apart from them for a while and we need to reintegrate without just jumping straight into it.
And I respect Mr. Gibson's position, but, because I think that's correct.
I'm sure that's your goal too.
Yes, it is. We want everybody to get along. It's just gonna take a little, rebuilding, let's say, correct?
Time is a good thing when time passes, but
But
I don't
anyway.
know whether I think that this is enough visitation to start off with. Unless you can convince me that they're in danger or something, it almost appears like a situation where she's done some egregious thing and the children have been at risk and trying to come back. I don't know.
Your Honor, without getting into specifics, there's been an incident or incidents, and I think Mr. Gibson
We
and I
don't want
both
to
have.
get it. I'm not gonna let that influence me approving an agreement because
Right.
you'd should have an opportunity to hear it out on both sides if there are any allegations that are mentioned. Now, how many hours did you say?
6 hours on Saturday and Saturday, you want to do it? 6 hours on Saturday for next 2 weekends straight.
Yes.
With the supervisor and then 2 weekends after that and then straight into.
Is that okay with your client?
Yeah.
Okay.
And if we have a problem, we'll bring it up.
Well, let's try to work on not having a problem.
Exactly.
If we have a problem, I'll be a problem. Everybody, y'all got 3 kids. And, from looks, y'all too, they're probably good looking kids, probably well established kids. I hope so. Hope they're doing well in school. So let's realize that we're going to be parents forever for these kids. Hopefully someday you'll be grandparents for some of these kids. So let's start anew today as far as overlooking anything that's happened in the past and try to work toward a conciliatory situation. You're gonna submit an order electronically?
I'll draft an order. What time's Ralph?
What time do you?
12 to 6, 10 to 4?
12 to 6.
Yeah, where's the pickup point?
Where you all want to exchange.
Police department?
Okay. The one downtown or the one north of town, which do you prefer? Downtown? Okay.
Judge, and there are on the divorce case, some pretty significant property issues. It's unlikely that we'll reach an agreement on that, and I guess we will need to file a request to get a hearing date with that and the custody.
Have you exchanged discovery yet on the thing? Well, let's wait to do discovery and see if we can decide what they own, and then we'll decide how much each of them owns that and all those other issues.
There's one big issue, and I can understand they don't want to agree at this point. I'll draft an order, Ralph. I'll send it up to you.
Okay, well, thank you all.
Thank you. We'll have it tomorrow morning, hopefully. Okay.
Wait a second, wait a second.
That would be the thing to do.
Yeah.
Yeah, but if we dismiss upon it.
Okay, thank you all. Is that complete? I think so.
You wait for the write-ups?
Okay, wait a second. We've got Shelton versus Storage.
Do you want our witness staying here? Would you
No,
like-
I request the room.
Okay.
She will go on first, you'll see what they say.
Okay, you want to call your first witness?
Okay, I call Haley Storch, Your Honor.
You want to come up to the Well, raise your right hand. So just like that piece.
Yes, Your Honor.
Looking for the microphone there.
Yes, sir.
Tell us what your name is.
Haley Storch.
Can you look straight into the microphone? I can see your face on the screen. You may inquire.
Okay. And Haley, can you tell us which county you currently live in?
Woodford.
Woodford County. And do you know the petitioner because you and him share a child together?
Yes, sir.
Okay. And how old is your child?
He's 7.
Well, what is the child's name?
Lucas.
Lucas Storch or Lucas Shelton?
Lucas Storch.
Okay. And where does the child live currently? That is his primary residence.
Woodford County.
Were
Okay.
y'all ever married?
No, Your Honor.
And I know you stated it earlier, but now you're under oath. Can you tell us the current time sharing schedule?
So Lucas is with me and he stays with me primarily and every other weekend is at his father's.
Okay. And do you believe that this current schedule in place serves the child's best interest?
No.
Okay. And again, I know we discussed reasons for this, but now you're under oath. Can you tell us why you don't believe this schedule is currently in the child's best interest?
Mr. Shelton had some actions that were quite concerning, that he would even make these actions. Even though they were dismissed, the actions still occurred. As well as his conduct to me, you normally.
Tell me what you're talking about.
The criminal charges he had
You need
with,
to tell me what they are. I can't presume that I know anything you said about.
yes, Your Honor, I apologize. The wanting endangerment, terroristic threatening. And
You know what they involve? You know what the allegations were?
the allegations of what I was told they were is that
Check is what she was told.
Sustained.
What do you have firsthand knowledge of?
that he was pending charges were terroristic threatening or leaving a scene, I believe, as well as discharge of a firearm due to he discharged a firearm in the presence of his father during an altercation.
Okay. Does he own a firearm to your knowledge?
From my knowledge, yes.
Okay. Do you know anything else about these incidents, where they occurred, when they occurred?
They occurred at his parents' residence.
Okay, and where is his parents' residence?
Here in Albany, on Old Monticello Road.
Okay. Who all was involved besides Mr. Shelton?
His father, his mother, his sister, boyfriends. And I'm not sure if the sisters were involved.
Okay. And that's all you know about these instances, correct?
Those instances, yes.
Okay. Now, has there been anything that happened in front of your child that you have firsthand knowledge of?
The altercation of which I was called for my mother, which he called me to end his weekend early on.
Okay, and tell us about that. What happened there?
Can we pinpoint a time before we get into that?
When did that happen?
10 o'clock at night.
Do you recall the day?
The day was August 17th, I believe,
Was it this year or last year?
2025.
Okay, now go ahead and tell us what happened.
I received a call at 10 o'clock at night that I needed to go get Lucas from Mr. Shelton, or he was gonna call the cops. And actually wasn't getting him from Mr. Shelton, I was getting him from Mr. Shelton's parents.
I'm gonna move on anything she's learned from the parents. If it's hearsay.
I was just about to ask a question on who she learned that from. I have been practicing